Well, to heck with the intro, I suppose. Good morning, everybody. Welcome to the Courtroom Files Live. This is a Monday already. The intro froze. Doesn't matter. Welcome, everybody. Nice to have you here. We'll start our day with Judge Glazer, Miami-Dade.
To 15 days for Broward County to pick you up. The reset date here is October 21st to make sure you are transported there. Have a nice day. Next, we have Carlos Tosco. He's at Metro West 7. Good morning, sir. How are you? Sir, you have an arrest warrant from Broward County. The warrant was issued September 20th of 2025. It says felony AF, reference aggravated stalking and domestic violence, and it says no bond. I will appoint the public defender's office for you. I don't know. Have you ever been to court on Broward on this?
No, ma'am.
So you may be entitled to a bond. I can reset this case in the afternoon to see if Broward will agree to a bond. How's that?
Thank you, ma'am. I appreciate that.
Thank you. We'll see you later. Then we have Jimmy Murray, Metro West 8. Good morning, sir. You were arrested on a warrant from Pasco County, Florida. The warrant was issued July 25th of 2025. It says criminal use of personal identification. Your bond is $10,000. I will appoint the public defender's office for you. If you are able to post a $10,000 bond, you can get out of jail. If you don't have any money for a bond, you'll have to wait up to 15 days for Pasco County to pick you up. The reset date here is October 21st to make sure you either posted a bond or were transported to Pasco County. Have a nice day, sir.
Bless you too, ma'am. Thank you.
Next we have is Amrit Kumaran. Good morning.
You want to also?
That's not.
We have Renee Smith.
Renee Smith.
You have Renee Smith. Pardon me. I apologize. Renee Smith. Good morning, ma'am. You have an arrest warrant from Broward County. It was issued September 18th of 2025. Not in custody, capias for grand theft in the second degree, and it says no bond. I will reset this case in the afternoon to see if Broward County will agree to a bond. All right.
Your Honor.
That's a VOP.
Your Honor, I did email Mr. Valcourt. He agreed to $15,000 and a no victim contact. I'll send the order. The alleged victim's name is Michelle Kiley. K as in kilo, I-L-E-Y.
So, ma'am, stay away from Michelle Kiley. You're not allowed to go near that person. You have to stay at least 500 feet away from them. And your bond is $15,000. Do you understand?
Yes.
Do you have her address, Mr. Wilson?
I'm going to get it right now. Thank you, Your Honor.
Thank you. So reset date October 21st to see if she posted her $15,000 bond or was transported to Broward County.
Thank you, Your Honor.
Then we have Amrit Kumaran. Good morning, sir.
Good morning,
you were
Your
arrested
Honor.
on a warrant from Manatee County, Florida. The warrant was issued September 29th of 2025 for violation of probation. I will appoint the public defender's office for you. Your bond is $5,000. If you're able to post a $5,000 bond, you can get out of jail. If you don't have any money for a bond, you'll have to wait up to 15 days for Manatee County to pick you up. The reset date here is October 21st to make sure you are transported there. Have a nice day. Transported or bonded out.
Yes, ma'am. I can have my friend to help me to
The best place to post the bond, though, is in Miami. You'll get out quicker. Call
Your
a
Honor, if
bondsman
it
in
please the
Miami.
court, could I get a release on on recognition because I have to pick up my car at the towing and my
It's
items.
not up to me. Most respectfully, it's the judge in Manatee County issued the warrant. It
Yes,
wasn't
Your
me.
Honor.
So I have to set a bond, sir. I'm
Thank
sorry.
you for the bond, Your Honor. I understand.
Have
Thank
a
you.
nice day.
Thank
Thank
you.
you. Kevin Borat is next.
Good morning, Judge.
Good morning, sir. You have an arrest warrant from Broward County. It was issued September 10th of 2025. Not in custody, capias, robbery with a weapon. I will appoint the public defender's office for you. I don't know if Broward will agree to a bond, but I'm happy to reset it in the afternoon. Mr. Wilson.
I did email Mr. Valcourt. He said it's a first-degree robbery. Unfortunately, he does want Mr. Borat extradited.
Okay, so there's no bond on the warrant. You're gonna have to wait up to 15 days for Broward County to pick you up. They usually come once a week. You shouldn't have to wait that long, but I'm resetting it in 15 days for October 21st to make sure you are picked up by then.
Can I say
Okay?
something, please?
You can say whatever you like. I'm
So
listening.
this is all a false. No. This is a fake story. They're
Of course,
saying,
you're presumed not guilty, but it's not before this court. It's
fine.
before the judge in Broward. So if you want to talk about it, I'm happy to listen.
no. What I'm trying to say is I was never in any of the location they're saying that I was in. This has never I've never done what they said I've done. Like this is a true lie that they created a story that I was in this place and did all this, which I've never did or done. So that's what I'm saying. How can this be proven? There has to be some surveillance video of me being there if I was there, right?
What county are you in? Is this Miami?
I'm in Miami-Dade County, yes.
The warrant's from Broward. Go talk to the judge in Broward. Speak to your lawyer in Broward County. I know nothing about your case, sir. Okay?
Of course. No
Have a
problem.
nice day. Reset
You too.
October 21st. Okay, we got to start the regular calendar. Ms. Corey, good morning. You want to
Good
announce?
morning, Rebecca Corey, Assistant Public Defender. Good morning.
Good. Before we start, I need 2 minutes. I have a little emergency I got to deal with.
Okay.
Sure you don't need any extra letters or anything?
Good morning once again, everybody. Happy Monday. Welcome to the Courtroom Files Live. You're going to have to bear with me here for a second as I am still trying to catch up because when we first went live, there was virtually nobody that was streaming their court, and now all of a sudden everybody is. So sometimes in this business, you run a little bit behind. Let's go here while she's gone. This is Judge Anna Marie Anzalone. I've got no idea what she's got going on, but she's always entertaining. So let's go to her court for a few minutes.
Period in time. We have no way of knowing that, short of her going into management and saying, hey,
Check that. This is Elizabeth DeSanto. Judge DeSanto. Judge Mom.
under possession to you. We have to continue to proceed pursuant to the court rule. So there's no way for us to go around that, unfortunately.
Well, counsel, if Mr. Katz is aware that Miss Marilyn Minefield does not reside at the property, and there's been communication with Kelly Minefield, then perhaps the request could be of Kelly Minefield while the two of you are having conversation as to where Miss Marilyn Minefield does reside, because you have knowledge and information she does not reside at the property. So I can tell you, I can guarantee I am not entering a default judgment against Marilyn Minefield because she does not have notice of these proceedings.
Well, again, Judge, we're going by, there's no way for the court to verify that. There's no way for us to verify that. Short of Marilyn appearing, we don't know. And we certainly can't take the representation from a third-party occupant as to her whereabouts, because it's not an attorney, so not an officer of the court. So we're kind of all in the same boat here. I mean, listen, at the end of the day, it's not going to matter, because if a judgment is entered, we can always just enter it as to all occupants and remove her name from the caption. That's not an issue, and I wouldn't be requesting a default today anyway.
Okay, counsel, I understand.
Okay, we kind of caught that in the middle and not all that interesting anyways. Sounds like a property thing. Let's go to Judge West. She just came online a couple minutes ago and see what's going on with her Monday fashion show.
The computer knows it's Monday. You're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from July 10th of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
Yes, ma'am.
You have? Did you hire someone?
No, ma'am.
Okay. So what I do, Mr. Battle, since you just got out of jail and made that bond, is I'm going to reset your case for about 30 days to give you some time to try to hire a lawyer. If you get a lawyer hired before the next court date, then bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers that you've talked to so that I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand?
Yes, ma'am.
All right, if you'll step in front of the clerk, she'll give you a reset notice. William Bonilla. Good morning, you're William Bonilla? And Mr. Bonilla, did you get a lawyer hired?
No, never.
Who'd you talk to?
I talked to Mr. Rojas and Miss Brittany Barnes, and I was trying to get in contact with this man as well.
Who's that?
Mr. James in Package,
Uh-huh,
and I haven't necessarily got in contact with him.
okay. So are you working?
Yes, ma'am.
Where are you working?
I work with Turner Industries.
Okay, so you need to get a lawyer hired.
Yes, ma'am.
This is gonna be your last reset. You were on bond and you got arrested for a new case already, so your bonds, it could potentially be considered a little low for the fact that you were already on a felony bond. I want you to have an attorney hired before the next court date. Don't limit it to 3. Start calling today, talk to as many as possible, and figure out who you're going to hire, okay?
Yes, ma'am.
Step in front of the clerk. Christopher Davis. Christopher Davis. Call the name, please. Mr. Davis, did you get someone hired?
No, ma'am. Talked to some attorneys, but I can't afford an attorney. I wrote a letter.
Who'd you talk to?
I talked to, actually, Rifles. Cheaper than anyway. Mr. Wilkerson Law Firm. I talked to Justin Gilmore.
Okay. Are you working?
The job is not started yet, but the habitat. It's coming up, but it hasn't come through the building 2 new houses.
All right,
I have
so I don't need to read your letter. I just need, since you did what I asked you to, I'm gonna have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. Make sure you fill it out accurately and completely. Don't just leave it all blank and put zeros. Put any bills you have, any income you might have, and then I'll take a look at it. If you step in front of the clerk over there, she'll give you that paperwork.
Since this has been a little bit of a hectic morning already, our intro video kind of froze on us. We've had to jump around a little bit. Let's embrace the chaos. Let's try something new. This is Fulton County, Georgia. This is Judge Alex Manning on the Superior Court. This is a compliance and motions calendar. No idea what she's dealing with, but let's find out.
How's it going, Income Owner Company? Good?
No.
Okay. I don't know a whole bunch except adios, but good job. We'll set it again, okay? Thanks. Adios.
I have a question.
Mhm.
My lawyer needs to come today, maybe the next call, I don't know.
Yeah.
Okay.
Okay.
It's not take the.
Go ahead.
I'll get his phone number and I'll call him with a Spanish interpreter. Can you write your phone down?
Position 8.
Yes.
Thank you, Miss Feely.
And I'll call you this afternoon.
Oh, okay.
It said, so for
Yeah.
My phone.
An email address.
Which one's your client there?
Good morning, Judge.
Good morning.
Camilo Compagna. I'm not sure what number that is on account, but
Oh, yeah, that's who we just, yeah. So were they in Cherokee County?
Yes.
Still in Cherokee County? Any bond?
There's a bond that's been set on misdemeanor offenses, but that bond has not been made.
Okay.
It's made in so
I'm sure they cut it off, right?
do you monitor? I presume, I don't know that for a fact.
Right. I mean, if they did, we just tell them when it gets out or when she gets out to go get another one put back on, get in touch with Second Chance. All right. Thank you so much. Okay. Uh-huh. All right. What about yours? Which one's yours?
Good morning, Judge.
Highfalutin.
Let's see, I'm covering for Ms.
Good to see you,
Stefano this
man.
morning. The first case of Ms. Stefano's is position 4, Ms. Young.
Yeah, over there. She seemed to want to see you because she hadn't been tracking since 9/9. So what I said was we'll put a new ankle monitor on her and give her another chance. She wanted to wait for Miss Steffo. So I said, well, if you want to talk about going to jail, we can wait for Miss Steffo, or if you want to just get a new ankle monitor. So I think she may have some complaints if you want to chat with her.
Yes, I would like to chat with her. I just came from Ms. Stefano and 2B. So
Okay, yeah, yeah.
I'm aware that there's some issues.
Oh, yeah, yeah, yeah.
Have a discussion with her and we'll come back.
All right, so we'll bring so did you bring Miss Ogletree here? So Miss Feely, that's one of y'all's cases?
I believe so, yes.
All right, she's in jail. You want to bring Miss Ogletree out?
She's custody.
Back to number 125 PI 005013. Short day today, Miss Feely. Mr. Jenkins?
Yes. No complaints, Your Honor, no complaints. She got a new case. Oh, you want to see it, Your Honor?
Yeah, the podium, that's fine. Miss Ogletree, when did you get arrested again?
Oh, I've been in jail for at the end of August. I did the whole month of September, and I came into October.
Okay. Did they cut that ankle monitor off of you?
It's at home in my pocketbook, cause I don't have a shower. I had to take a bath with it. And they kept shocking me with it in the water. So
Yeah.
I didn't never leave the house.
Wow. I
I
didn't
never
realize
left. And they kept calling, but they never did come by there. I kept telling them to come over to my house. But
Yeah.
They didn't come.
Huh.
I ain't never went to her house, but I'm tell you this, Miss, Your Honor. Did they investigate this where she first time I had a pistol on her and the sun was shining on her? I had so mad that day, I forgot to tell you all to pull her camera, her doorbell camera, so that you all could see it.
So, Miss Feely, you'll pass that on to,
Yes.
okay, yeah.
That was a lie.
Okay, I got you.
Ankle monitor today.
So,
The ankle monitor.
Ankle monitor camera.
you said it was at home.
Yeah. I want to go home. I've been in that place. I'm locked up for nothing.
No, you got.
So what we're,
I can't afford that no $10,000. I got y'all $20,000 bond. And she called around and told the people, I'm stalking her. I ain't stalked her.
so all we're talking about today is the ankle monitor. So you have problems with it. So when you get out, will you go by a second chance and get another one and tell them the issues you're having?
Yeah.
Okay.
Could they put it on my arm?
So, Madam Ankle Monitor, is there any way to do something?
Fulton County would have to approve the watch for us to put it on. It's still gonna be the same condition. It's an electronic device. It cannot be submerged in water. However, you can still shower and
Right.
sponge bath, I guess.
So, but I
It
mean,
doesn't shock them. It just prevents the device from working.
right. So, who pays for that, or is it the same?
It's the same. It's just Fulton County have to approve it because currently Fulton County doesn't pay for that.
Right. So, what do we need to do to get that done?
Just an order that states the watch.
Okay. All right, but now if we get you a watch to put on, it's gonna be like,
Man, but I got stuff at home to wrap that. I can wrap the top. I got stuff at home.
okay. So, but you won't just like go swimming in it, right?
No, I'm gonna be good.
I'm sure you are. So, Mr. Jenkins,
I'm with the bracelet.
so she's got that as other. Do you want to just reinstate this one and make it a watch?
I have no objection to that, Judge.
Ms. Feely?
Yep, that's fine.
Okay, so we'll reinstate it, and what we'll do is say, replace the ankle monitor with the,
GPS watch.
what's it called?
GPS watch.
Yeah, the GPS watch. All right, we'll get you one of those soon, okay? All right, thank you, ma'am. Have a good day.
Just, can I ask you, Your Honor, why is I thought this was for my barn hearing.
No, I think,
You got a couple of things going on, and I'm happy to come to the back. and-
yeah, you may have something coming up on that pretty quickly.
Ma'am, I cannot spend another day in jail, Your Honor. My mother deceased. I have a brother that's stronger out on heroin. He's auctioning off the house. His name is not on the deeds. He got falsified deeds. My cousin had me locked up right here for nothing. She said I had a gun. She's having sex with my husband. She gave me full-blown AIDS. I can't deal with a whole lot of
We're
this.
not
I need
on
to
the
go
county.
home.
We're not
Right.
on the county.
I got you.
But we do need to get you in for a bond hearing.
I can't stay here another day. I've been here for 2 months, and ma'am, I'm about to lose everything that my mother them left me. Behind
On
a
the
liar
20,
and a
on the
thief.
24th, I know you got a bond, so Ms. Feely will,
It was for 10,000. I just got out. I shouldn't even been locked back up.
Yeah.
But
So how about
they
Miss-
never investigated the crime
Right.
from the beginning, Your Honor.
right, so how about Ms. Feely talks to your lawyer and they try to get you on another bond counter? I'm sure Ms. Feely's gonna make that note on her counter right now. Okay? Thank you, ma'am. All right, what about, thank you, Don Tavius McCrary? Okay,
Query was,
thank you, Ms. Feely.
I don't know. Oh, no, the one we just did was stating the bond and she's gonna do an order for the GPS watch.
Get all that, Madam Court Reporter? Did you get all that?
Sure did.
Okay.
Clarity.
See this one.
Where is this? Anya. Gabriel. Are you doing the add-ons?
Yes,
Oh.
yeah, because I got inmates, they wants to go ahead and do the inmates real
Oh,
quick.
first,
Because there's
okay.
only, well, besides her, there's only, I think,
All right.
7 more.
Okay, so we're doing the inmates first, no problem.
Yeah, that way they can get them out of here.
Yeah.
So we got, yeah, it's number 1 on the add-on, Don Tavius McCrary.
Yes.
How you doing, Mr. McCrary?
Good morning.
So, we apologize we didn't get you back any sooner, okay, but I got a little cold going on, so I was out that day.
Okay.
Judge McBurney didn't want to cover the calendar for some reason, but probably because Miss Feely's so aggressive with it. Right, Miss Feely? But, so I think before he had a lot of violations. What is it? What you gonna do different this time, Mr. McCrary?
Make sure I charge the ankle monitor up. And do the right thing by the,
Keep it charged, right?
yes, ma'am.
And hopefully, I mean, yours don't have too much. Hopefully we can, let's see, how long was his on before? Do you know?
I have something starting in March. I'm not sure if it was prior to that, though.
Is that when you got it on in March?
I got it on in February. I got arrested in January and I got it on in
I'm
February.
sorry, I can't see. 2/26/25. My apologies. Is when it first started with us. I'm uncertain if he had it prior to.
Okay, how about this? How about, Ms. Feely, how's this sound? We give him another reset, bring him back in no time. If you're in compliance, Ms. Feely's gonna probably argue to take it off
I'm looking at his charges here.
because he's got an agasol on a peace officer.
So he's been in jail for 2 weeks.
Yeah, 15 days.
I mean, that, if he's not violating the law and he did appear for court because he got arrested, is my understanding.
Well, because he wasn't charging, yeah.
Right.
So we'll just put another one on him when he,
That would be our request.
well, so we'll reinstate it and put the, reinstall the ankle monitor. Okay? All right, thank you, sir. Appreciate it.
Thank
Uh-huh. Keontae Hurd, number 2, 25 PI 000658. It looks like he has another hearing in front of Judge Hughes on the 23rd. Mr. Hurd, how you doing?
Good.
Oh, so we got to speak really loud, okay?
Good.
Is that really loud?
I mean, it's loud as I could. This is my regular voice.
Lean down just a little bit to the microphone.
It's my regular voice right here.
Okay. So, all right, sorry about it being 15 days you were in there, but what you gonna do different this time?
Keep it on the charge. Keep that shit. Keep them off and keep the charger with me.
And if charger breaks?
Go get another one ASAP.
Outstanding, outstanding. Any objection, just reinstating, and, okay, so we'll reinstate your bond, they'll put an ankle monitor on you before you leave, okay? Just keep it charged.
Okay, man.
All right, thank you, Mr. Hurd. I think he had two, so yeah, three. Yeah, he had three cases. All right, so number 5 is Kenyon McCrary. 23 SC 190635.
Add on. Thingy. Yeah.
And Mr. Hurd was number 2, 3, and 4.
Section 5 and 6. Yes.
And Mr. McCrary is 5 and 6. He's 23 SC 190635 and 23 SC 190621.
Good morning, Judge.
How you doing, Mr. McCrary? So tell me what you're gonna do different.
I'm gonna keep it charged, Judge, all the time.
All the time, right?
Yes, ma'am.
Be where you're supposed to be, not go where you're not supposed to go.
Yes, ma'am.
So when we bring you back again for compliance, they're gonna say, perfect charging.
Yes, ma'am. I
right,
promise.
Mr. Go ahead.
2 weeks got me right in the head.
Mr. Jenkins?
No objection to reinstate.
All right, you go with that, Ms. Feely? All right, so we'll reinstate both your bonds and get you another ankle monitor, but if you have any problems with it, make sure that you call them, okay?
Yes, ma'am.
All right, thank you, sir.
You're welcome.
Uh-huh. All right, Destin Wilson, that should be the last one, Lattimore. Yours gonna be next, Mr. Abt. You got here just in time.
Thank you, Your Honor.
Wait a minute, Destin Wilson, I show that Destin Wilson isn't in there anymore. Unless. Hold on. Do what? I can't hear you.
It's supposed to be released September 25th, September.
Okay, so.
That's information on the order. Because it was a 200.
Okay. Oh, okay, yeah. And they put it back up. He was released, I think already. They put it back on him because he was a juvenile.
His mom, he was not released. He's being held at Clayton County right now.
Oh, well, if he's held at Clayton County, then I guess that's on Clayton County charges?
For a failure to appear.
Oh, in Clayton County?
Yes, but under the circumstances that they sent the letter for his court date to the wrong address. So when he was supposed to get out, they didn't release him because of that situation, and he was transferred to Clayton County.
Okay. I mean, have you dealt with Clayton County on it yet?
Actually, they won't allow me to speak with anybody. They're telling me that he has to call in from jail to get a bench warrant release or something like that. And he's supposed to talk to the attorney. The only thing that they gave me was his attorney name and wouldn't provide me with an email address or a number.
The attorney's name in Clayton County?
Mm-hmm. And I tried to contact the public defender that we were dealing with before, because she sent over the release papers for them because we thought it was just, they wasn't releasing him. So she sent over the papers for that. But she still hasn't contacted me either. So at this point, we're actually not knowing what to do. Right
Kind of like, I'm sure Miss Felia can get your name and number and she can pass it on. If you'll give her, she'll come back there and get it from you, okay? And we'll see if she can help you out. And then give her that, who's the attorney in Clayton County?
Catherine Jackson.
Is she from, Lister and Holt?
I'm not sure. The lady at the PD office was
Oh,
very helpful.
okay.
Yeah.
All right, I'm sure that, Miss Feely can get your public defender here to get in touch with. Maybe they can help you figure it out, okay?
Okay, and then, is she, will another court date be provided or?
Well, no, because I think we set a date for him to get out here, remember? Because we had just this date to this date, yeah, so. Thank you so much. All right, let's see. All right, Mr. App, we got Darius Hurd.
He is present, Your Honor. I have spoken to the ADA assigned to that case, Ms. Willingham, and we have a negotiated plea. We're working on just getting a plea date. But if there are issues with an ankle monitor or some other compliance issues, I'm unaware of
That's
them.
the main calendar.
It's number 9, 25 SC 003287.
In the main calendar.
What's happening with the ankle monitor?
Oh, Your Honor, we're good. Pretrial and no known violations.
Well, there it is.
Good. All right, plea time.
Okay, that's fine. Thank you. When's your date? Do you know?
We don't have one yet because of my horrific conflicts and leaves.
Oh, okay. All right, thank you,
Get
sir.
worked out.
All right.
Ms. Willingham and I are going to diligently work on getting a court case.
All right, thank you. Thank you, sir. Have a good one, Mr. App. Good to see you.
Thank you, Your Honor. Good to see you.
I got number 10, Deontay Bryant, 25 PI 000833. Round up, Mr. Bryant. I think he's from Conflict now, isn't he? How about Mr. Bryant? How's that going?
Oh, Your Honor, we have several violations for Mr. Bryant. There's an apartment complex on the same road, but further down. So we have his listed as 111 Oakley Industrial Boulevard, but he frequents 5474 Oakley Industrial Boulevard. It is not in the same complex. Have him there on 9/14, 9/18, 9/20, 9/22. Our agent did speak to him at one of them. He said he was on the way to Zaxby's, but he'd been at the apartment complex for quite some time. And then visiting stores on 9/15 at 7860 Senoia Road for 6 minutes. On 9/16, 7895 Senoia Road, and 7854 Senoia Road.
I think this is Mr. Hines with Conflict, or is this an old case of his?
Too new for that to be that much. This is it.
Number 10? I didn't know if that was one of, didn't Mr. Hines go to Conflict?
Mr. What position?
Princeton Hines, number 10?
Oh, no, he is a private now.
Oh, okay.
Firm.
So do you think this would have been a private one, or when he was with PD or Conflict? Let's say home.
Sounds like he was retained. He did retain Mr. Hines.
Oh, so you retained him?
He just late right now.
You retained him?
Yeah, I paid him.
A little closer to the microphone, a little louder.
I said, yes, I paid him.
Okay, you paid him.
Yeah, his, Mr. Hines' entry of appearance has his, firm at PO Box and not the public defender's address.
Speaking of that, speaking of that, we're going up. We got Mr. Bryan up here.
Good morning, Your Honor. Excuse me for being.
No, good morning. How have you been?
Good, how are you?
Doing well. So, Mr. Deontay Bryant, 25 PI 000833. Go ahead, Ankle Monitor and Company. One more time for Mr. Hines.
We have several violations from leaving the home. We have his address listed as 111 Oakley Industrial Boulevard. He is frequenting a apartment complex at 5474 Oakley Industrial Boulevard. We have him on 9/18, 9/20, 9/22, 914. Additionally, some stores on 915 at 7860 Sonoya Road, 916, 7895 Sonoya Road, and then 7854 Sonoya Road. Mr. Bryant does email frequently about job interviews. These are not correspondent to those emails.
Go ahead, Ms. Hines.
Yes, Your Honor. I believe that Mr. Bryant has been in touch with his pretrial officer and will correct his communication with the ankle monitor company going forward.
So, okay, but why is he leaving his home and frequenting the other address? Because this says 24-hour curfew, work, legal, emergency, one religious worship service per week. And I don't see him released on the pretrial services on any of these because he had a $65,000 bond. None of them were through pretrial.
So these are other family members who are taking him to work or to job interviews, I'm sorry.
So you work at the apartment complex at 5424 Oakley Industrial.
Well, no, so that's his grandmother's place and she was taking him to a job interview.
So what would you like, Mr. Jenkins? Why have you been communicating with pretrial instead? Because you're not on pretrial services instead of the ankle monitoring company.
Your Honor, I can't hear.
Yeah, you got to let microphone back up. I know these people talk louder.
Okay, when I'm finna leave out my house, I email them and let them know I'm going to an interview or I'm going to my job.
Email whom?
The second chance people.
Your Honor, he does email for job interviews. We weeded those out. That's what I was trying to explain. Those are not correspondent to these. This is an apartment complex that he's staying at for an extended period of time. It is not his home address.
So this is somebody you're going over there to see for extended amount of time.
No. So say if I'm finna go to my job or I'm going to an interview, I'm gonna go to somebody close to like my grandma's house or somewhere where I know I can go here and then go here. Like go to my job and go to my auntie house or go here, then go to my grandma's house, stuff like that.
So I don't know if they're taking you, why can't they come get you? Because that's probably what you need to be doing.
Because no, I be catching a bus and I be walking. Like I don't really be having.
I know there's a bus that comes over there to where you live.
Yeah, but it's like a certain time it come. It only come at 8 o'clock in the morning to 4. So if I go to work, I have to stay at somebody's house until that time come back around for me to catch the bus or me to make it back home, stuff like that. So I might sit after work or before work, I'm at my grandma's house.
What time do you usually go to work?
5 o'clock. Or whenever they just call me. Like it's not a set schedule. They just.
So I think you ought to get them to change your schedule so you can work during the daytime.
I was trying to work on that. It's like difficult with this job.
You got to work out something because you can't keep going to these addresses.
Okay.
So I don't know why you're going to your grandmama's house at so early and staying there until then, but this is your bond conditions because you got 2 counts of armed robbery, 2 counts of aggravated assault, 1 count of home invasion. So the people of Fulton County want you to abide by these bond conditions, okay? And you were released on these bond conditions with an ankle monitor, kind of as a little bit of courtesy so you wouldn't have to stay in Rice Street. So the thing is, if I give you one more reset and you come back here and that same stuff's happening, I'm gonna send you back to Rice Street. Because you're not following the bond conditions. See those guys that came in here a few minutes ago? They've been in jail for 15 days. You gotta say something, just look at me.
I understand what you're saying.
Okay, so you're gonna do what you're supposed to do?
Yes.
Yes.
Yes, ma'am. I said yes, ma'am.
No, you ain't gotta say all that, but yes, I will.
Yes, I will.
Nothing's gonna stop me from violating it.
I will follow the rules and do what I'm supposed to be doing.
I didn't realize you were so tall.
Yes, Your Honor.
He was so tall till he's standing up beside me.
See each other off Zoom.
Exactly. All right, we'll give him one more shot. Last shot. We'll put him on. When's our next one? We can get him on. Huh?
Haven't got the date
Is it November?
yes, it'll be November.
It'll be November. So you get that little test thing since November, okay?
Okay.
All right. Thank you.
Thank you, Your Honor.
Thank you. It's good to see you again.
Good to see you also.
All right.
Well, she's entertaining. I've seen her once or twice. I just haven't had a chance to show her on the stream before because it's kind of hard to catch her court. So choose your own adventure. Put a 1 in the chat if you want to stay here a little while longer. Put a 2 in the chat if you want to move on. We'll give you a minute to respond while we catch this other guy. And I've been working feverishly behind the scenes this morning because like everything was broken, even the on-screen chat, and I'm like fixing things one by one. But I think I'm finally caught up now. Anyways.
Let's just see. Ganesh?
Yeah, he's with my office.
He's with your office or conflict?
He's with me. My
Oh,
office.
okay.
He's not calling.
So it looks like that. So how is he doing?
Your Honor, we have several violations. First being on August 14th. Defendant was at 1193 Cleveland Avenue, East Point, Georgia, on 824, 8043 Binice Circle, East Point. And then on 9/12/2025, 4375 Cascade Road. Also, we have Mr. Mathis, what appears to be on a cruise to the Turks and Caicos.
That's a little bit outside of Fulton County.
When I was released, I was told no
No, it's not.
restriction by a work employee. This is my first time ever going through something like
Hold on,
this.
you put your hand down. I gotta hear from him. I'm gonna see what he says. Go ahead, I'm listening.
But I was saying, when I was first released, I was told no restrictions by an employee who put it on me. Then when my ankle monitor actually had fell off because they improperly put it on, I went and put it back on.
When you were first released.
No, ma'am. Not when I was
When you
first.
were first released, you were told no restrictions.
Yes, ma'am.
All right, let me read you something from your bond conditions. You ready? You ready?
Yes, ma'am.
All right. 24-hour curfew except for work if job title schedule is submitted to the attorney. Medical, court, and attorney visits. Stay away from 1355 Westview Drive. No weapons, no firearms, no drugs without a valid prescription. No further contact with any known gang members. So that sounds like restrictions.
Yes, ma'am.
So you did have restrictions.
I understand that now.
Okay.
But even when I had contacted them and told them about the trip or whatever, they never said no, you can't.
Contacted who?
Second chance. My mother emailed them.
Did your mom? Okay, hold on, mama. Who's wearing the ankle monitor?
George. Me.
Your mama don't have one on?
No, ma'am.
Then why is she emailing them? This is a you problem, not a mama problem.
Yes, ma'am.
Ms. Feely, Mr. Jenkins, Mom, I'll let you talk, but I mean, I don't want you making excuses for him because, all right, come on up here, Mom.
Well, before we get started with that, this is, I wanted to put this on the record several times. We are begging the court to ask for these violations ahead of time for this exact reason.
Right.
I mean, and it's over and over, almost every single time there's violations, we just stand up here blind and have to throw up an explanation versus constitutionally due process. We've asked them to send it.
How soon can we get how soon could you get at least Ms. Feely, anything?
So these violations are already sent to the court.
Mhm.
We just bring the notes with us.
Who are they sent
They
to?
go to a generic email address, SCA@FultonCountyGov, something like that. Like these are not like, we just pull them all up. We bring different details like dead batteries because
Yeah.
that goes in one report, but this is not.
So what's that email address? I'm just curious who it gets.
Right, because we need notices of what's going to be thrown at them before they step up here. And I've asked before, and it may not have been this exact lady, but I've definitely.
No, yeah, I know you said it, but I think she said it gets.
SCA.anklemonitornotice@FultonCountyGA.gov.
So is that to Ms. Burns?
Yes, it is. There's several people on it because we get tons of communication back. I think there's like some courtroom officials and they send it to specific people.
So do you ever see Ms. Katara Burns on there?
She does not respond to these.
But is she on there?
I don't know. It's a distribution group on your side,
Oh, okay.
unfortunately.
Okay, we'll look up that email address. All right, go ahead. Mama, what's your name besides Mama?
Kimberly Bussey.
Okay.
Okay, when they first put the ankle monitor on, they told him no restrictions. I did let them know that he was he's going to college, so that he would be traveling for these specific reasons. I called the young lady, I spoken to her, she gave me an email. I explained to her that we gifted him with a cruise trip for graduating from high school on top of his class. We gifted him with a cruise, and she said that everything was okay. She provided me with an email. He was right there with me, and I sent over the email. She said she just needed the dates, the time, and when he will return back to Atlanta. I have the email.
Was that in July?
He just came back.
I mean, was that in July when he got out?
Yes, you gotta.
Because I mean, I just read what was on the bond conditions.
Yeah, I understand that, but when speaking to the young lady,
That ankle monitor?
yes, ma'am, at Second Chance, yes, ma'am. Because this is his first time. This is both of our first time going through this. You know, of course, when you're a mother, you're gonna go through these things with your children. So I was trying to make sure I'm right there and supporting him and
Sure.
with this.
Well, I graduated high school. You gonna send me to Turks and Caicos?
And I told he had a football scholarship, but of course, wrong place, wrong time. It kind of.
So can I count on you to make him do all the emailing instead of you?
I'm teaching him. He has to be responsible. I'm teaching. Yes, ma'am.
Where's the ankle monitor now? Has it been,
Just tracking.
do you have a job?
Yes, ma'am. I was working at Georgia Tech. Currently I gotta restart my activity because of the trip. I was through corporate.
All right,
tech.
so do you hear this? It's a 24-hour curfew except for work, if your job title, schedule, and everything's submitted to your lawyer and to the ankle monitoring company.
Yes, ma'am.
You can leave for that. Only if you have a job and you get them your schedule. Medical, court appearances, and attorney visits. You got to stay away from 1355 Westview Drive. No drugs, no alcohol, no firearms, no communication with any gang members. Known gang members, I'd probably go with known, unknown too. And it also says, can't have any co-defendants with your co-defendants, Mathis, Slayton, and Slack. I don't know who they are. They're co-defendants. They were arrested.
You say them names?
I mean, it says Wilson, Slayton, and Slack. They may have nicknames. One says, Davion Seals. These are all people arrested with you. I don't know. The nose.
No, they probably.
I hear you, man.
But
I hear you.
it's crazy because they're related. They all cousins.
So do you know who those people are?
We don't know them by nicknames.
All right. That one, Sean Slack.
No, we don't know.
Oh, let's take a second, go back, and William Slayton.
Slayton, Sean Slack, or David Seals.
Well, no, none of them.
Okay.
And Taurus Wilson.
Taurus Wilson is his cousin. That's a cousin.
That's all those people.
You can stay away from all of them? Okay.
We'll give you another November date, okay?
Okay.
Yes, ma'am.
But if it stops charging, doesn't do anything, you better call, you gotta let Second Chance know. Do y'all prefer emails? Do y'all prefer phone calls?
For the emails,
Who you want the email from?
the defendant.
There you go.
Yes, ma'am.
All right, you get another chance. I'm in a good mood.
Thanks.
Thank you.
Mama, I'm not real good at contacting monitoring companies. Can you do it? And then Mama's like, well, we're trying to raise him right. We're trying to teach him by giving him a cruise for graduating high school while he has pending criminal charges. I'm fired up this morning. All right, this is entertaining. We will come back, I'm sure, as long as she doesn't kill her stream. But let's go to Judge Stevens. He has a guy in a looks like a fresh zebra costume. So let's check that out.
22-39417 is called the State of Texas versus Jacoby Damon Broussard. That's you, right? And you were here with Mr. Adams, your attorney, and the state's attorney does the defendant. We have a formal reading of the indictment and arraignment here. Can we proceed in a summary fashion?
Oh, yes, sir.
In summary, sir, this indictment, which was handed up on March 9th of 2022, it alleges that on or about February 17th, 2022 in Jefferson County, Texas, you committed the first-degree felony of murder by shooting the complainant Christopher Thomas with a deadly weapon, namely a firearm. Do you understand what you were charged with here?
Yes, sir.
If convicted of a first-degree felony, you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? An agreement's been reached in your case where whatever sentence shall not exceed a cap of 30 years in prison. So really, we've got two options, I guess. You've got deferred or unadjudicated probation for up to 10 years in length on probation, or confinement no less than 5 nor more than 30 years. Those are going to be the two options.
Probation is not an option.
And not a deferred.
I don't believe so, Judge.
Okay.
Correct me on
What do you say?
I didn't think so either.
I think by statute, it's
Barbara, thank you for gifting that membership. Very kind of you. I do appreciate it. So while we're waiting for Judge Stevens to continue reading whatever it is that he is reading, I do want to point out that this Friday is our 1-year anniversary of this channel. It was on the 10th of October last year that we posted our first ever video. So creeping up on a year this week. So look forward to all of you spending Friday with me. I think that'll be a great day. And Wednesday is our 150th live show. But if all goes according to plan, the 150th show will have a little bit of a twist to it. So be sure to tune in Wednesday as well. And yeah, he's really digging into whatever he's looking at. But we're in the Wayback Machine here just a little bit, so I'm going to bump him forward slightly. Oh, and now he's muted. So he was reading, but now he's muted, and that just makes me sad. We don't get to see how that finished. It's been a weird morning here at TCF, but that's okay. 9 to 11% more Judge Boyd. Let's go there.
All right, we're going to go on the record. The court is calling 2025 CR 0077972, State versus Jesus Enrique Alexander Velasquez. Could I have the parties announce?
Attorney for the state of Texas. Thomas Taylor, ready?
And are you Mr. Velasquez?
See.
Yes. All right, we're here for our motion to set bond. And it appears that the state has agreed on a bond of $10,000. Is that correct?
Yes, Your Honor.
All right, and what is Mr. Velasquez's criminal history? I'm assuming since he's charged with continuous violence against family, there's a previous assault case? Excuse me, you all can't do the side chatter because the court reporter is taking down everything that everyone is saying. And I'm sorry, could I have the interpreter, if you could raise your right hand for me, please? Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand. If you'll state your name for the record.
My name is Catalina Delgado, Delgado, license number 2222.
All right, and state.
So he had a previous assault yet in April 11th, 2024. That became part of his current continuous violence case against the family. Otherwise, he doesn't have.
And the previous assault, is that the same complainant? All right, Mr. Velasquez, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
It's huge.
Yes.
All right, so here's the thing. Either you're gonna speak in Spanish or you're not.
Habla español. Yes, sí, ma'am.
I'll speak Spanish, yes, now.
All right. And the reason why I say that is because we have an interpreter here. All right. Have you ever had any type of mental health diagnosis?
I'm sorry, what did you say?
Have you ever had any type of mental health diagnosis?
No, ma'am.
Have you
No,
ever
ma'am.
been, thank you. Have you ever, yeah, I guess we're gonna speak in English and in Spanish. Have you ever received any type of medication for any type of mental health treatment?
No, pues.
No, Judge.
Have, in the past, have you ever used any type of drugs?
No, pues.
No, Judge.
All right. This is what the court is gonna do. What is his current bond set at? Counsel, what is his current?
The clerk says there's no bond at this time.
There's no bond that's been set?
It was originally 10,000. He used the court date and he was remanded without something.
All right, so we have someone who's missed a court date. Counsel, why did he miss his court date?
Respectfully, at the time, his new wife was in the hospital and he had to pawn his phone at the time because he had no money and he had to come up with 40,000 pesos. And it was on the Mexican side. They all live in Laredo. But now he will have a phone. Now he will have a place to stay. Now they lost. They had a very tragic incident with the new wife. And at this point, Your Honor, he's no longer with the victim in this case. At this point, Your Honor.
Well, here's my question. The wife that he was helping in Mexico, is that the same wife who's the complainant?
No, Your Honor, it's different. It's a new one.
So this new alleged person, is that his girlfriend? Why he has, so he has a girl.
She's on Zoom as well.
So he has a girlfriend in San Antonio.
No, it's in Laredo.
No.
Well, this wife that you're saying that he had to get money for.
No, this is a new wife.
And is this new wife somebody other than the complainant in this motion?
Yes, Your Honor.
So he has somebody in the complainant in the motion. Is this complainant in the motion his girlfriend?
No longer together, Your Honor. No longer together.
And you say there's someone on Zoom who wants.
Yes, she's going to be the new wife that he had to sell his phone to be able to pay for a medical emergency. And I can call as a witness if she should be on Zoom, Your Honor.
Oh, she is. Could you unmute, please? And show video. All right, so the fact that while she's waiting to unmute, so the fact that he had to sell his phone, that still doesn't explain why he was not in court.
He didn't have a way to get notification about the court date. He did not know. But now he understands how important it is to make his court appearances in the future.
So how long has he been in custody?
2 meses.
2 months, 2 months and
2 months and 2 weeks.
So the warrant for his arrest was issued in July.
He may have some time from before, Your Honor.
No. I mean, I'm saying he was issued in July. So is he saying he's been in custody since July?
No, es porque en junio fue cuando empeñé el celular.
No, because in June, that's when I pawned my cell phone.
O sea, no tenía forma de saber cuándo tenía la corte.
I had no way of knowing when my hearing was going to be.
Y no tenía trabajo tampoco.
And I also didn't have a job.
Porque me despidieron por haberme movido a México por la emergencia médica que tuvo mi esposo.
Because I was fired since I had to move to Mexico for the medical emergency my wife had.
No, when you are given when you have a charge, you're given a court date before you're released. Wasn't he arrested for this offense? If he was arrested for this offense and it was not at large, he would have had a court date when he was released from the jail. That's my question, counsel.
Yeah.
No, estuve cuando yo salí la primera vez, estuve preguntando.
When he first got out, he was asking.
But no. So here's the thing. If he's talking, I need the interpreter to interpret.
Cuando salí la primera vez, los primeros meses estuve preguntando diariamente sobre la corte y ellos me dijeron que dejara de hablar porque ellos me iban a avisar.
When I first got out, I kept asking. I asked for about a month and they told me to stop calling, that they would let me know.
He was calling daily also.
He was calling daily.
I mean, well, that's what he's saying. Where's the proof that he pawned his phone and he paid a medical bill? Do you have that?
Yes, Your Honor.
Yes.
I just got email from the wife.
You need to show it to the state.
And this is why you had to sell his phone. Yes, have you seen the good phone? I don't think people.
That's not.
I apologize, I just got email. So I talked to. And but let me just show you how that works. This is for the phone. If you close it, you see the hospital bill. In the same email. On the right hand side, it's all in Spanish, but we can use interpreter to maybe explain the hospital bill. Okay. He can read the document and explain to the court.
I
How
don't
much.
need an explanation.
Thank you.
I cannot fluently speak Spanish. However, I can read Spanish.
Thank you.
It's actually similar to French. All right, this is what the court is going to do. The court is going to set your bond at $30,000. Who's the complainant?
Azumet Daughters. That is spelled AZUNHET.
H-E-T?
Yes, Your Honor. And then Torres is common spelling TORRES.
All right, the court is going to set your bond at $30,000. There's to be no contact with Azumet Torres. And there's to be GPS partial for employment until further notice. And I'll ask that GPS fees be waived. And Norma, give him a set date. Your jury trial date is set for November 4th. Thank you.
You're
welcome. Donata? Yes. Okay, all right. Thank you. Yes.
All right, let's give Judge Stevens another try. Let's do that.
Aggravated robbery, and it states you used a deadly weapon or exhibited a deadly weapon, namely a knife, that was capable of causing serious bodily injury or death. Do you understand what you're charged with here? A first-degree felony means you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand what you are facing here? An agreement's been reached in this case where you would be pleading guilty, placed on deferred or unadjudicated probation for up to 10 years in length, and fined $500. Is there any loss in this? No. Is that your understanding of the agreement?
Yes.
If I follow this, you have no right of appeal of your case as well as the previous case. Do you understand?
Yes.
How do you plead to this charge?
Guilty.
Guilty or not guilty? I'm sorry, I spoke over you. Go ahead.
Say it again.
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
I show you in each case what is marked as State's Exhibit 1. Did you sign those documents voluntarily, understand them, discuss them with your attorney, or the contents true and correct? State's Exhibit 1 tendered into evidence
Without objection.
and without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's really involuntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and you are totally satisfied with the representation provided by your attorney, Mr. Kimler, who is now deep in thought. Is all of this true and correct? States Exhibit 1 in each case made a part of the record for all purposes. We're going to order a pre-sentence report. I think that's the right thing to do. We'll be back in about 4 weeks. And then each side gets to sound in, give me any other information so I can know as much about you. I can make a most informed decision on this case, these 2 cases, and then you can proceed with your lot. You understand what's happened today? Okay. We'll see you back in a few weeks. Anything else? That is all. Thank you.
Okie dokie, let's go back to Judge Boyd, new contestant.
Hello, Mr. Jimenez.
Good morning.
Good morning. How are you doing today?
Good, how are you?
Oh, I cannot complain. It's a beautiful day outside. Not too hot, not too cold.
I like that hot.
All right. All right. So where are we on this sanity evaluation?
It's still pending, Judge. Mag Court went ahead and set it for January 8th. It's my understanding they're having a little bit of an issue with the availability of the evaluators, Judge. So we're still just waiting on that. In terms of discovery, we did give acknowledgement of discovery to the clerk here, the court, for processing, Judge. So there are 45 videos. We believe that discovery is intact at this point. So there's that issue, Judge. I also did file a motion to set bond. He's currently remanded without, Your Honor.
Okay.
I wanted to see if the court would have availability this Thursday to hear that. I need to get some criminal history information from him, as well as call potential witnesses. And I did just file that last week through e-filing.
All right, Norma. Set this for Thursday for them to have their bond hearing, and then state in defense. If you confer on a jury trial date, it'll be your jury trial date and plea deadline date, because I know you're waiting for the sanity evaluation. So if you all could pick a date, perhaps in February.
Yes, Your Honor, will do. And upon getting that date, Your Honor, can I communicate that to the coordinator?
Yes. Oh, I think she's getting it now.
Oh.
All right, February 3rd will be your jury trial date and plea deadline date. If your attorney wants you brought sooner, he will let the court know. And you'll also be back on Thursday for a hearing on your bond motion.
Thank you, Your Honor.
You're welcome.
Judge.
You too. Counsel, is there anything else?
Nothing further, Your Honor, may be excused.
Yes.
Thank you.
All right, let's head over to Texas. Judge Mercer and his Monday first appearances.
Appearance process every day. We have Mr. John McDaniel, Assistant Public Defender at the jail. In the courtroom, we have Mr. Mitchell, our prosecutor. I'm going to ask that he introduce himself.
Jake Mitchell on behalf of the state.
Thank you. Can you see and hear both of us at the courthouse, Mr. Corporal?
Yes, Your Honor.
Great. All right, so first case we do have friends or family here on Patrick Pender. So let me see Mr. Pender first, please. Mr. Pender, give us just a second so I can get you back on camera. I can see him on the computer, but there he goes. Mr. Pender, you're here for first appearance accused of one count of battery. Mr. Pender, your mother's in the courtroom. There is probable cause for the charge, Mr. Pender. Your criminal history is not bad, Mr. Pender, overall. Mr. Pender, I'm going to listen to the attorneys and I'm going to address your bond or your release status. Mr. McDaniel, anything?
Yeah, we just asked the court to consider conditional release.
Mr. Mitchell, anything from the state?
Nothing from the state.
Mr. Pender, I'm going to let you pick between a bond and a conditional release. If you'd like to post the bond, it's $2,500 cash or surety. Surety means you could go through a bondsman if you wanted to. I am going to offer you a conditional release. If you want to choose a conditional release, that's fine. You will have a condition of no contact with the alleged victim either way, whether you choose the bond or the release, no contact with Sandor Kirkland and Mr. Pender. You can pick whether you prefer the bond or the release. It's entirely up to you. You would also have just the standard conditions of every conditional release. Any questions, sir?
No, sir.
And would you rather post the bond or accept the conditional release?
Conditional release.
All right, so let me tell you, Mom, what's going to happen next. Next, ma'am, they're going to let him get dressed and let him use the phone if he wants to. He may not need to since you're here. Then they're going to bring him to the courthouse because the courthouse is where the conditional release office is at. It's inside the county judge's office downstairs. When he gets here, Mr. Pender will meet with one of the conditional release officers, probably Mr. Goodson here. And Mr. Goodson, or it'll be your case, Mr. Goodson? Mr. Ham's. They divide them up by the type of case it is. Mr. Ham will meet with him, go over the conditional release with him, explain him all the rules of the conditional release, give him a copy of the rules in writing, give him a chance to ask questions, and then he'll be free to go. The other thing they'll do is they'll give him, just a second, they'll give him a notice for his court date. When will that be done? October 27th at 9 a.m. will be the notice they'll give him, and they'll get him to sign for that notice. You had a question. Usually it's 45 minutes before they get them in their regular clothes and get them back to the courthouse. Okay. All right. Your mom will be here to pick you up, Mr. Pender. Any questions?
No, sir.
Have a good day. Sandor Kirkland. Good morning, Mr. Kirkland. You're here for first appearance accused of one count of battery. Also, the alleged victim in your case is Patrick Pender. And Mr. Kirkland, there is probable cause in your charge. The problem you have, Mr. Kirkland, is you're already on state probation, it appears. Let me see if the attorneys have any additional information in your case, Mr. Kirkland. Mr. Mitchell.
Just nothing for right now.
Is the state asking that he be held to give Judge Garcia time to look at the warrant? Or
Yes,
the new
I
complaint?
assume that's what you were going to say. So yeah, the state's requesting.
So, Mr. Kirkland, you also would be a conditional release candidate if it were not for the fact that you're on state probation. That complicates things quite a bit. What I'm going to do in your case is set you a bond of $2,500 in this case, but I'm going to hold you 7 days. I'm going to ask Mr. Mitchell to notify state probation of your arrest, and then they will seek a warrant from Judge Garcia. Judge Garcia will read the complaint in your case, and Judge Garcia will decide three options she has. Number one is to issue a no bond warrant. Number two is to issue a warrant but put a bond on it. And the third option she has is just give you a notice to appear. So if she chooses a notice to appear, you also would be a conditional release candidate, just like Mr. Pender. But I can't assume that. I don't know what she will do. The other factor that she will have access to then that I don't have now is how you've done overall in probation. In other words, if you've got another violation that comes, like you didn't report in last month, or you're behind on some financials or community service or something, she'll have all that information, which I don't have at the time of first appearance. So right now you've got no bond, but it's not the strongest violation of probation case I've seen. It's basically a he said kind of thing, and they had chose to arrest both because there is probable cause for both charges. So you've got no bond for 7 days. If Judge Garcia does something before 7 days, I'll see you before then. Otherwise, I'll see you in 1 week, and we'll see if they've done anything with a VOP. Any questions?
No, sir.
Have a good day, sir.
Jacob, I don't recall how good that complaint was really laid out, that it was not an affray that was done in public. It was basically two of them fighting, sounds like between each other, and there's no witnesses on the pier except each other. I don't know, when you read the complaint, I don't know if that one complaint like on his really clarifies those issues until you read both complaints, so I don't know if there's some way you can let Judge Garcia know about that.
Yeah, I'll let them know. I'll let state probation know, and I'll let Judge Garcia know. If this goes into circuit court, it'll probably be my case anyway, so I'll keep you both informed.
Thank you. The next case on the docket is Mike Murphy. Good morning, Mr. Murphy. You're here because you've been accused of trespassing. Mr. Murphy, there is probable cause for this charge. I'm going to appoint the public defender's officer to represent you, Mr. Murphy. I'm going to ask that you listen to Mr. McDaniel, your attorney.
Your Honor, I spoke to Mr. Murphy. He's going to plead of no contest to the charge of trespassing and 25452 MM understanding. He's going to be sentenced to 11 months, 29 days probation, $370 fine. No contact with the apartment complex. It was Chipola Apartments. I think he lives there, I think next door or close by right there. And I think he walks through there going to his job at
the Cave City Pawn Shop.
The pawn shop. And I let him know he needs to stay away from there. He takes care of the squirrels or something out there.
They take care of the squirrels. Sure.
Mr. Murphy, you need to understand you cannot be on their property, period, at all. You can't, according to the complaint, you were sitting on the bench on their property. You need to go around their property. Don't even walk across their property because it's obvious they do not want you on their property for whatever reason. I don't know the benefit. I don't have the benefit of having that information, but it's clear that they don't want you there. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
And Mr. Murphy, is that the plea you would like to enter, sir?
Pardon?
Is that what you want to do? Take the probation?
Yeah, yes, sir.
Mr. Murphy, I'm going to accept your plea of no contest to the charge of trespassing, withhold adjudication of guilt, place you on probation for 11 months and 29 days. Mr. Murphy, you'll have the standard conditions of probation, plus a special condition that you have no contact with Chipola Apartments or any of their property. Mr. Murphy, pay $370 court costs and fines. What's going to happen, sir, is they're going to bring you to the courthouse after you get dressed. They will let you use the phone if you wish to for transportation purposes. And then once you get here, you'll meet with the probation officer. And after they explain everything to you and give you a chance to ask questions, you'll be free to go. So, Mr. Murphy, you're going to be at the courthouse probably in 30 to 45 minutes and be free to go after they meet with you. Any questions, sir?
No, Your Honor.
Have a good day, Mr. Murphy.
Thank you.
Yes, sir. Joyce Stevens.
Judge, did you get my text message about Ms. Stevens?
I did.
Nobody's there with her for her, or?
No, sir. No one's in the courtroom on behalf of Ms. Stevens. So, Corporal, what we need to do with Ms. Stevens, I guess, is see if we can get life management to do an evaluation of her, please.
Yes, sir.
Based upon her history and the complaint, I don't know that the jail is the best place for her, but I don't know that unless she's got some family support system, I don't know that the community is the appropriate place for her right now without some kind of support system. She's already got a $1,000 bond on the warrant. I put that bond on the warrant when I signed it, so she has a right to post that bond, Corporal. She does have a condition of no contact with alleged victim or her property already on that warrant. So if she posts a bond, she has a right to, but I need life management to do an evaluation before she's released. Mr. McDaniel or Mr. Mitchell, if anyone hears from family or friends on her, I was going to consider an ROR this morning, but only if I had somebody that's going to kind of keep an eye on her. I don't know what else to do. Mr. Mitchell, Mr. McDaniel, any suggestions?
Your Honor, I just asked maybe to make it $100 cash bond in case someone does, her husband does want to come up here and get her out, or she tells me she's very confused. And she told me she has a daughter that's in Tampa, but she also told me that her daughter was in Colorado and it was very unclear. She said her other child was deceased and, and he was someplace else. She told me before, so it was kind of confusing. So I would just ask maybe for a cash bond for it. If someone does show up, that can hopefully get her out easily.
Mr. Mitchell, any objection to a cash bond?
No objection.
So Corporal, change that to a $100 cash only bond, still have the condition, no contact with alleged victim or her property. When law enforcement called me, Mr. Mitchell, about the warrant, they told me they were going to investigate the possibility of a Baker Act. But if that didn't work and they did not think it would, they didn't think she'd qualify, that they would have no choice but to seek a warrant. She allegedly walked into a neighbor's home uninvited after being given trespass warning, but they felt there may be some mental health issues related to dementia or something like that. That's a sad case. I don't know really what to do with it other than try to keep the peace, protect the public, and maybe get her out if we got somebody to keep an eye on her. So if Ms. Stevens is still there tomorrow, Corporal, let's add her to the list tomorrow and see where we stand. But if she's posted bond, if we get a life management report, they need to give that to Mr. McDaniel, and Mr. McDaniel will circulate it to us if it's something he can share with us. And that's it for the first appearance docket. We do have Mr. Landry that showed up this morning. Mr. McDaniel, it's news to you and me also. It was when I walked upstairs, Mr. Goodson told me, Mr. Landry, come on up, please. Do you have the heading of that case, Mr. Goodson?
Yes, sir. May I put on the record a few things? So Mr. Landry got a conditional lease on.
What's a full name?
I'm sorry, Christopher Landry, case number 25/456 CF charged with aggravated assault. He was given a conditional release on October 1st. I instructed Mr. Landry on October 1st. He seemed very coherent to what I was saying. After lunch, the sheriff's department called me, Deputy Register called me and said that Mr. Landry was in Alford on 231. Anyways, the sheriff's department did a Baker Act on Mr. Landry Wednesday afternoon. Mr. Landry showed up this morning in my office. I asked him when he got out. He got out Saturday morning after the Baker Act. Mr. Landry informed me this morning he has nowhere to go. He was concerned with the curfew because he has a 6 a.m. to 6 p.m. curfew. He has no residence he can stay at. His dad, he informed me, was in Southeast Hospital. He was living with his dad. His dad called the sheriff's department, issued a trespass warning. The sheriff's department issued a trespass warning against Mr. Landry. His great grandfather brought him up here this morning. I asked him, could he stay with him or his aunt or his mother? Mr. Landry informed me he has nowhere to go. So that's why I brought him up this morning to let you all discuss the case.
So, Mr. Landry, when you were given a conditional release last week, you had a condition to live at 1794 Virginia Street and not to change that residence. Who lives at 1794 Virginia?
My father.
Okay. And you can't live there for some reason?
No, sir.
And tell me why?
He is now in the hospital under conditionals.
Okay. So was the trespass warning from that address or somewhere else?
Yes. Mr. Landry, the sheriff's department, his father called the sheriff's department, I assume from the hospital.
I was just informed this morning that the sheriff's department was called the other afternoon to my father's for a trespassing warrant that my dad accused me of stealing some stuff out the house while he was at home. So he had me trespassed.
Okay, so you can no longer live at 1794 Virginia.
No, sir.
You have, in the past, we've dealt with you in the past, you've lived with the grandmother, you lived with your mother, had different situations like that. Where else can you live?
Nowhere. All I know to do right now is go to talk to Stephanie.
Who is Stephanie?
Stephanie Colbert.
And Miss
And
Colbert.
because she's been trying to get me into a group home
How long has that been going on?
about a month now, about a month or two now.
And they haven't had any success finding somewhere for you to go?
I'm not sure. I haven't talked to her since about 3 weeks before I went to jail.
So where'd you stay last night?
I did. I'm not going to lie to you. I went and stayed at a friend's house on his couch, just so I wasn't out in public.
When did you get the trespass warning? Today?
Saturday evening.
So Saturday evening, you've had no place to live.
Yes, sir.
And that friend's place is not a thing. That was a one
Yes,
night
sir.
deal.
He went and got his wife's brother yesterday, so they have no more room. But he said if have to, that I could put a tent in his backyard and we can run a stitching cord out there. So I have power or a camper.
You have a tent or a camper?
I can get one. I know someone that has a tent. My Aunt Crystal.
So if you have a tent, what extension cord, what's that going to provide?
They said they would run a extension cord out from the house to my tent, so I would have power and a light and a fan.
Mr. Mitchell, what's the state's position? This is one where the state or defense, somebody asked for a curfew. And I imposed a curfew from 6 a.m. to 6 p.m. And as I already mentioned, he did have a condition to reside at 1794 Virginia Street. Mr. Mitchell?
Yeah, I believe both me and Mr. McDaniel both suggested curfew would be for the best right there. As for everything else, nothing else from the state. I really don't know, Your Honor.
Mr. McDaniel?
We're on Zoom still, aren't we? Or, I mean, I'd like to ask him something about it.
We are, but
Can we come off?
We can go off of Zoom if you want to ask him something that may potentially be embarrassing. You don't want to be broadcast. So, ladies and gentlemen, that's going to conclude first appearances for today. Let me do.
And that's the end of that. Let's head a little bit north. Let's go back to Judge Manning for a little bit.
No violations, Your Honor.
Good job, Mr. Watkins. You having any problems whatsoever?
No, ma'am, but I'm trying to get me a job real soon. I'm trying to see if I'll be able to work.
Let me see what you, does it say you can't work? Hold on. Get it, hold on, let me pull it up. Did your bond condition say you couldn't work?
I think I can, but I want to see where I'm supposed to send the information to.
All right, let's see. So you got out in May? Sound about right? So this says, stay away from 1380 Atlantic Drive Northwest, 24-hour curfew except as follows: job interview, school, medical, court, meeting with legal team, no weapons, no replicas, no drugs, no drugs without a prescription. So, yeah, you can. So what do you, hold on a second. He's doing good, mama. You got to let them know though. Like if you're going to interview wherever, you got to tell them, ankle monitor company, hey, I got to interview at wherever.
Okay.
So if it's like tomorrow at 9 o'clock, I got an interview tomorrow at 9 o'clock at this place. And then when you get back, you say, okay, I'm back from my interview. Now your interview don't mean you go by Turks and Caicos.
Okay.
Okay. Go to your interview, come back. And then when you get a job, you call them, you say, okay, I got a job at here. And then this is my schedule. So they'll know. Okay.
Okay.
I have no problem if on the way home, you have to stop and fill up with gas.
Okay.
You know what I'm saying? I mean, life happens, you know, you got to go to the, you know, you get sick, your mama gets sick. I get it. But just as long as you let them know, everything's cool.
All right.
All right. So email them. Yes, ma'am.
Before you leave, if you'll see this young lady right here, she'll give you a card that has all the information to contact us.
All right.
There you go. Now you, yes, ma'am. Not your mama, you though. Yes, ma'am.
Only question was, he was, his dad, that's the question. It was, it's like mobile mechanic. So he actually goes, that's why he hasn't been going to actually work with his dad. We didn't know whether that's safe enough.
So what does your dad do?
You're a mobile mechanic, ma'am.
Okay. Well, does he know where he's going?
Yeah. Yes, ma'am.
I mean, yeah. I mean, as long as you know where you're going.
Okay.
So he may say he may have like 3 different customers. So it'll be a different address to different places or as the calls come in.
Yeah, so you would just jump on that. If you get that card, you jump on there and say, you know, I'm working with, you know, dad, whatever your dad's name is, here it is. I'm going, this is the address I'm going to, 136 Pryor Street. And then when he gets another one, now I'm going to 185 Central. Now I'm going to, you know, Rice. You just got to tell them those addresses where you're going. And then when you finish up at your last one, just say, all right, I'm going home.
Yeah, ma'am.
Does that make sense?
Yes, ma'am.
And like I said, if your dad has to stop at, you know, Eats, which is breaking my heart, it's going out of business, closing, to get dinner, then you can stop and get dinner and go home. I get that. You know, just stop, pick up something, go home, okay?
Okay.
All right. Thank you, sir.
All right.
Yes, ma'am. But yeah, get that card over there. Yes, ma'am.
Other thing was like, get a haircut to look presentable, to go to the job interview. That might get some years.
Well, let them know you got to get a haircut. I mean, you know, some of your basic like. And what?
This place,
Oh, yeah, you gotta go get an ID.
okay.
But you just gotta let them know. Now, don't let it be you go to Turks and Caicos and you see you go and get a haircut, all right? Just tell them where you're going.
Okay.
Hey, your mama's trying to take care of you. Don't holler out. Thank you, mama.
All right, thank you.
All right. Looks like, all right, that says Joshua. Did you get his card? Did he get a card?
He did.
I think so. Okay. Looks like, okay, I got a lot of people in here. Oh, no, I got Trazion Brown. 17 SCs 155641. How's this one doing?
Your Honor, this is Attorney Aisha Broderick's case, but I'm standing in to make an announcement for her.
Okay. How's he doing on there?
No violations at this time.
Perfect. What's the announcements? Oh,
That he's doing great. He's been checking in with Miss Singleton and I'm not aware of any problems.
he doesn't have a court date yet?
Yes, Sean, he's had a few. He, the 17 threw the court off a little bit.
Yeah.
He did docket until he wasn't arrested until 2024.
Oh, because it was re-indicted. Okay. If you have any problems, same thing. I don't know what your bond conditions are.
He just recently received, permission to work, so he'll be starting a job tomorrow.
So did you get that,
It was modified.
yeah, you get that card from her?
On the way
Your
out.
Honor, we take this from pretrial. When they're supervised by a pretrial officer, we get their schedule from the pretrial officer.
Right. I don't know. I would let them know too. That's what I would do.
Fair.
That's what I would do. You know, because like I'm supposed to have a pretrial officer a day, but they're short staffed, so they don't have anybody. Me? I would just email them anyway. Can't hurt, right? Here's where I'm working, here's where I'm going, anything. Gotta go get a haircut. This is what I'm doing, okay?
All right.
Outstanding. Have a good one. Thank you. All right, let's see. Quintus Crane, number 16, 25 PI 005688. 16.
Good morning. Hey, how you doing?
Doing well. How about what we got on going on for Mr. Crane?
No known violations, Your Honor.
Hey, Mr. Crane, good job. Let's see. How long have you had yours on?
7/18.
Since July.
Since July. Okay. All right, we'll get you back in a few months. Is this one? All right. We'll get you back in a few months to see what we want to do with it, okay?
Okay, thank you.
All right, just let them know anything you're doing.
Okay, okay.
All right, thank you. Who's the little baby? Look at the thing. All right, let me got Raymond Washington, number 17, 25 SC 003019. Raymond Washington. Raymond Washington, let's see. Make sure I haven't been DWAP. Well, it's supposed to be a final plea in front of McBurney the 9th.
Yeah.
Oh, well,
Well, what is that, Thursday?
yeah, I'll email him, and if he wants me to do a, 1 minute. Hold on.
Yeah, that may be the best thing if he's got.
Yeah, I'll email McBurney and let him know and see what he wants to do.
No problem, Judge.
Okay. All right, number 18 is Ronell Anderson. 24 SC 001701.
Your Honor, there may be a disposition on that one.
All right, let's see. Mm-hmm. All right, yeah, it looks like it is. So
All right, good.
I guess y'all got his ankle monitor, right?
We do.
Okay. I'm gonna take him off. And then I've got number 20, Tavarius McCrary. 25 PI 005279. What's going on with Mr. McCrary?
Your Honor, we don't have no violations, just want the court to know it appears to live in the same neighborhood as the exclusion zone, which does make it a little risky on our part, but just want to be noted for the court.
So do you live near 6475 Connell Road?
That's my house.
That's your house?
Yes.
So this says you're not supposed to be at 6475 Connell Road.
Yes. I haven't been there.
So where have you been staying?
I stay in Parramatta at 8004.
Is that where you've been showing him?
Wilkinson, that's what they should have.
Hold on, so it says that it shows you within that area near Connell Road. Have you been over there?
Oh yeah, I have family that stay right on the street, right around the area, the whole area. I have family and friends that stay around.
Okay, but you can't go over that way. That's the thing.
You mean over there where they say I was supposed to be within 400 feet? That's what it says.
What's the exclusion?
I haven't been 400 feet within the house.
Ours just says stay away from 6475 Connell Road, South Fulton,
So what does it make it in?
and so we have it at.
So what address are you going to that's close to there?
It's like a couple of them. I have family that stay on the back street.
Okay, you gotta speak a little, I'm sorry, what?
I have family that stay all around the whole area.
Okay, no.
Like the back street.
Here's that house.
I just don't go with that.
Look.
I just don't go with.
Here's that house.
Okay,
Do they live next door?
no,
Across the street?
no, I don't go that close. I know the next door neighbor, I don't go that close. I go with
No,
them.
no, no. Your family, do they live across the street?
No,
Do they live on that same street?
yes.
All right.
Palmetto address, it just doesn't have to stay home, and so he's frequently there. We do not have him specifically at this address. It's very close, very hard to track sometimes.
So if he gives that well, yeah. What do you suggest, Mr. Jenkins? I would suggest they come see you. Or if you go see somebody, don't meet them on that road. Like stay off of that entire road. Here's the deal, if they tell somebody that you're violating it, the cops can come pick you up. And they don't care if you're at your uncle's, you're just not supposed to be over there. So,
Well, I didn't know I was supposed to be in the whole area.
yeah, so, I mean, they have to make it like an area. So is there anywhere else that your relatives can come see you?
Just stay them around.
Little louder.
So I just had to stay them around there.
I mean, somebody doesn't live close to there, right?
Well, I was staying away from the feet that was said to stay away from the house. I didn't go within those amount of
All right,
feet.
so how about we don't go on that street and go a couple streets over?
Okay.
Sound good?
Yep.
All right, just stay away from over there, okay?
Okay, can I ask you a question?
Uh-huh.
Who do I report to when the person is evicted from my home?
When the person's what?
Evicted from my home. They said I'll be.
I guess you need to let your lawyer know. Is it still Miss Gerber?
I guess I thought I was supposed to let them know. Because they say I'm supposed to be out for house arrest because the person that's in my house is the
So
reason
you
that
gotta
I'm
go
on.
through your lawyer first, Miss Feely.
Okay.
You wanna, so Miss Feely will get your number and pass it on to whoever it's assigned to, okay?
Okay.
And you can talk to them, that way they can talk to the state.
Okay.
All right. Now we got number 21. I think it's the last one on here is Kendrell Knox, 24 SC 003821. Kendrell Knox, going once, going, huh? Okay. Going once, going twice, nothing. All right, I'll get with, she said the notice was returned. I'll get with Judge Schwall's office, okay? I think that's it. Anybody else? Yes, ma'am.
We come back to position 4.
Uh-huh.
Miss Young.
Brian Young, 25 PI 005178. Yes.
Your Honor, when I first stood up about this case, I needed to speak with Miss Young in the
Sure.
hallway. We had I think, lengthy and productive conversation in the hallway, and what I believe to be the issue is that there's a problem with her monitoring device. She says she's been charging it. In fact, she showed me pictures of her charging it after the day that apparently it hasn't been charged. I think it was September 9th was the last time it was shown charged. Correct. She showed me a picture on September 19th where it's charging and you can kind of see the green light. So I think there's an issue with the device. So I'm suggesting she get a new device and a new charger. She's also brought to my attention that that she has an issue with her bond conditions. And so I was wondering if Your Honor would entertain an oral motion for bond modification.
What's her problem with her bond conditions?
Her issue is that she's currently on a 24-hour house arrest with exceptions for medical appointments and court dates. But she has no work exception, and that's what she's asking for, seeking. She has a freelance photography business that before this case she was running, and that's how she was supporting herself. And of course, without a work exception, she can't leave the house, cannot photograph anyone. And so we're asking for her to be allowed a work exception so that she can continue her business or restart her business, get her clientele back and support herself.
I'm trying to read Mr. Jenkins.
I have no objections to work exceptions as long as she keeps the monitoring company abreast of where she will be in the exact location, but I have no objection to work.
Yeah, that's fine if you want to submit one, but here's the thing. They've called you more than once about charging. I know they have.
No, ma'am.
Okay, so they're lying. They've never called you. They never called you. They never let you know on the 28, 20, like, right? Okay, so.
Your Honor, we did have a discussion about contact with the monitoring company with Second Chance.
Right.
It was my suggestion and, my client thought it was a great idea. I said, every Monday, take 5 minutes, call the monitoring company, say, hey, checking in, want to make sure I'm charged. Are there any problems? They can
Or
say,
emails.
no problems. That way there's a paper trail. I know they take down every record of contact. That way, once a week, she's checking in, making sure everything's fine, no problems. And when she is working, she can email her schedule and call them and say, hey, I'm photographing this wedding. Here's the address. I'll be there from so-and-so and so-and-so. I said,
Then when you
there's
get
no
home.
such thing as too much communication.
Unfortunately, right now, you gotta let them know every move you make.
Yes, ma'am.
But you gotta, they're gonna say they called you, and if they got notes in there,
May I ask what number do they have on file that they're
I don't know, you
contacting?
can ask them. I don't.
We'll make sure that.
You can ask them, but here's the thing. If you change your phone number or you change your email, that's a you problem. You gotta let them know. They can't just keep up with it.
Yes,
All
ma'am.
right? So go over there and get it swapped out. Y'all take care of it.
Yes, ma'am.
Thank
And
you. Anybody
I'll
else?
I'll
Oh.
submit the amended bond order.
Yeah, yeah. You want to submit it to me or?
Yes, please.
Okay, yeah. Anybody else?
Thank you.
Thank you.
Nope, that's it. Thank you, Madam Court Reporter. Sorry everybody was talking so low.
Okie dokie, let's go back to Judge Boyd. She has another contestant that's approaching.
All right, the court is calling 2024 CR 012855, State versus Christopher Gutierrez. Can I have parties announced?
London West for Mr. Gutierrez.
And are you Mr. Gutierrez? All right, Mr. Gutierrez, Mr. Arguelles was appointed to represent you. Your previous counsel had a medical issue and asked that they be removed from your case. Your attorney is entitled to 10 days to prepare for trial. Of course, he was just appointed. Do you still wish to continue or do you wish for him to have 10 days?
All right. Get it all done.
I'm sorry?
Get it all done with.
All right, and Mr. Arguelles, are you waiving your notice?
Yes, Your Honor.
And have you had sufficient time to speak with your client and review the case?
Yes, Your Honor.
All right, and counsel, have you received all discovery?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Gutierrez, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, are you waiving the reading of the indictment? Counsel, are you
Yes,
waiving
Your
the
Honor.
reading? State, are you proceeding on the indictment as presented? Any objection?
No objections, Your Honor.
Mr. Gutierrez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with theft of property less than $2,500 with 2 or more previous convictions. The punishment range is as a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case? I'm sorry? No. I'm going to go through it slowly with you. And if there's something, here's the thing, take a deep breath. All right, so I'm going to go over this slowly with you. If there's something you don't understand, let me know, all right? And counsel, I know that you've explained this.
Yes, Your Honor.
Sometimes questions are complicated, so I'm just going to break it down. Do you understand you have a right to have a jury? That would be 12 people who would sit, and they would get a chance to hear whatever evidence the state would bring, and that evidence would be brought in the form of witnesses. Do you understand? And your attorney would have a chance to cross-examine those witnesses. Do you understand? And do you understand the state would not be able to call you as a witness if this were a jury trial? Do you understand? All right, because you're entering into this plea bargain agreement, The state is not going to call any witnesses. Your attorney is not going to get a chance to question any witnesses. Do you understand? And do you understand also that if anyone wants you to testify, you've given up the right to say, I'm not going to testify. Do you understand? All right. Is there anything you do not understand? All right. Oh, thank you. Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Gutierrez, has anyone promised you anything than what the agreement is? Has anyone threatened you, coerced you, or placed you in fear to enter into this agreement? All right. Are you satisfied with the way you've been represented? Did you understand by entering this plea, if you're not a U.S. citizen, you will be deported? Do you understand? If you're not a U.S. citizen, you won't be allowed to legally re-enter the United States. Do you understand? If you're not a U.S. citizen, you are going to be denied naturalization. Do you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. This is your plea bargaining agreement. Did you review it with your attorney? Did you understand it? So what you've agreed to is to serve 1 year in the state jail facility. There's a $1,000 fine. What I can tell you is legally, whatever time that you've been in custody, I have to give you credit for that time. Do you understand? But for the court, your agreement is 1 year in the state jail facility and a $1,000 fine. You're not applying for probation or deferred adjudication. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State? This paragraph, that's the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? When you sign that, that means that you're waiving your right to appeal. So you can't come back and complain about this plea unless your attorney has filed some motions. I've heard those motions and made a ruling on them. Do you understand? Counsel, are there been any such motions?
No, Your Honor.
So to the offense that you're charged with and this indictment, how do you plead? Guilty, not guilty, or no contest? State any evidence.
No objections, Your Honor, for purpose of the plea.
All right, and state you may be excused. Did you review this document? It's the waiver and stipulations. All right. Again, you understand you can go to trial if you want to go to trial. You understand? All right. So did you understand and sign this document and all the places you should sign it? Did you understand that the state, again, they're going to present their evidence to prove your guilt by entering into the record police reports and any prior judgments that you have to prove jurisdiction? Do you understand? Court will find that defendant has knowingly and voluntarily waived and stipulated to testimony of stipulations. Court will accept into evidence state exhibits 1 and attachments, and the court is reviewing the same. All right, counsel, is your client stipulating that the person who's listed as S1 is also D1, and that is your client?
Correct, Your Honor.
All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
Let the court follow the agreement.
All right, the court will follow your agreement. The court is going to sentence you to 1 year in the state jail facility. There's a $1,000 fine. Time and money run concurrently. I'm going to give you credit for any time served. I'm going to suggest the therapeutic community or recommend that. It will still be up to you whether or not you want to be in that program. It doesn't increase the time you're in custody. It's just to help you with any type of issues you may have, be it mental health issues or drug issues. Do you understand? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? And did you understand it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Mr. Gutierrez, you're gonna have to change because you're gonna get to a point where these state jail felonies, the range of punishment is gonna end up being 2 to 20. You understand? All right, good luck to you.
Thank you, Your Honor.
Thank you. You too. Thank you, counsel.
I don't know about you guys, but this morning is absolutely flying by. It's lunchtime already on the East Coast. So with that in mind, let's check in on Judge Glazer, see how she's holding up because she's still working.
Judge, Mr. Vandergeest does not have the funds for the $5,000 bond. Would Your Honor consider a $1,500 to $2,000 bond? He's hoping.
Maybe a house arrest though, Judge, but I'm.
Not only did he strangle her, he's beating on her.
Right.
I don't know.
There's a recording. Victim says he's gonna kill me.
Does he have priors? I forgot. Let me see. Can I have this paper?
I only see one null process, non-domestic.
I can lower it a little, but I'm setting a bond. I'll set it at $3,000.
Thank you.
Thank you, Judge.
Thank you, sir. Just stay away from the victim, please. Next, we have Alejandro Vega Torres. Good morning, sir. You were do you speak English?
Yes.
Are you arrested for grand theft of a vehicle? It charges a second-degree felony, but there's no value for the stolen tractor trailer. I will appoint the public defender's office for you. So there's probable cause for grand theft, a third-degree felony. He has a prior conviction for this from December. I'm setting a bond, $2,500. This tractor trailer was stolen in Kentucky. Good day, sir. Next is Adam Rodriguez. Mr. Rodriguez, good morning. You were arrested for burglary to an unoccupied dwelling, possession of burglary tools and criminal mischief. Public defender's office will be appointed. So what's the burglary tools? He breaks into homes and squats there, that he's known for that in this neighborhood. But I don't know what the burglary tools are. State?
It just says tools.
It says screwdrivers, pliers. I don't know. Sir, you are ordered to stay away from the victim's residence at 15576 Southwest 103rd Street in Miami, Florida. You are not allowed to go to that location. You must stay away from there, sir. I'll set a bond. Count 1, burglary to the unoccupied dwelling is $7,500. Count 2, I don't know. You want $1 on that? Is that good? $1 for count 2. Count 3, criminal mischief. It says the damages were what, $200, so that's $150, count 3. And stay away from the victim's property at 15576 North Southwest 103rd Street. Good day, sir. Next is Christopher Johnson. Page 11.
Good afternoon, Mr. Johnson. You were arrested for false imprisonment and domestic battery, battery. I will appoint the public defender's office for you. Right, the victim's here. I'm promoting her. If she can unmute and put on a video, then I can swear her in. Good morning, or good
Hi,
afternoon.
good afternoon.
Hi, raise your right hand to be sworn, please. Do you swear or affirm the testimony you are going to give in this proceeding will be the truth? If so, state I do.
Yes, I do.
Thank you. Please tell me your name.
My name is Alexa Ruiz.
Are you afraid of Christopher Johnson?
No, I am not afraid.
Do you want the court to order him to stay away from you?
No, that will not be necessary.
What year were you born?
1995.
All right, thank you. Okay, state any questions?
I mean, no questions, but I will note that the defendant's got prior DV arrests, including a prior 2-year probation sentence for domestic violence.
Ma'am, you understand that court cannot protect you against any future violence from Mr. Johnson without a
Yeah,
stay away order?
I understand there won't be because this was a misunderstanding and a lot of the, well, 90%
Ma'am, you
of
don't
the
have to make
information.
excuses for him. I just want to know if you want a stay away order.
No, I'm not making excuses. I'm just saying that the things that were written on the
Actually
police
are.
report are false, like things that didn't happen.
Well, somebody called the police.
I do see a bandage on the victim's face.
That's not a bandage. This was a burn that I got burned with a hair iron.
Ms. Corey, any questions you have for Ms. Ruiz?
No, Judge.
Thank you. All right, so Mr. Johnson, I will enter a modified stay away order from the alleged victim, Alexa Ruiz. You are allowed to have contact with the alleged victim. You are prohibited from being physically threatening or violent towards her in any manner whatsoever. So only friendly, nonviolent contact is permitted. Do you understand that, sir?
Yes, ma'am.
Also, do not.
actually planning to marry her in the future, so.
Okay, even when people get married, they still can fight, so you have no violent contact with her, you understand?
I understand.
Also, do not engage in any criminal activity, do not use or possess illegal drugs. Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. Do you understand the stay away order?
Yes,
The modified stay away order, okay.
Modified stay order, even.
Only not friendly, nonviolent contact is allowed. Do you understand that?
Yes, I understand, Your Honor.
Thank you. I guess pretrial, I'll give him pretrial. Alternate bond, count 1, false imprisonment, $2,500. Count 2, battery is $1,000. So he can get out for free with pretrial services or post a $3,500 bond. Thank you for coming in, ma'am.
Okay, how do I go about now on my part, how do I go about getting him out of there?
So somebody from pretrial services will call you and to verify he has a place to stay. Does he live with you?
Yes.
You can put on the pretrial order, he's allowed to live with the victim. Okay? They're gonna call you, or you can call a bondsman and bond him out and pay the $3,500, your choice. You can get out for free with pretrial, or you can post the bond. Okay?
Okay, understood.
you.
Thank you,
Have a good
Your
day.
Honor. Have a great day.
All right, now on page 12 is Ronald Mounts.
He refused court, Your Honor.
He refused court. Let me review for probable cause.
Victim is Willie Rouse, Rouse.
Judge, we can waive his presence.
Okay. Appoint the public defender's office, waive presence. There's probable cause for the charge. Bond is $2,500. You said refusal?
Yes.
Oh, I thought so. Thank you. Right now we have on page 12, Eduardo Riecho Hernandez. Is he there? Is he refusing?
Refused. We'll waive his presence.
Appoint the public defender's office, waive presence.
Victim is Arturo Barcenas, Barcenas.
Thank you.
There's probable cause for the charge. I'll set his bond at $1,000. What about Mandy Pena?
Refuse court.
We can waive his presence.
Appoint the public defender's office, waive presence. Shouldn't it be possession of a controlled substance at a correctional facility?
We could charge it that way, but
Mm-hmm. All right. Our bond is $2,500. Then we have on page 14, Johnny Fernandez.
Is a refusal or waive his presence?
victim is Benjamin Lukens, Lukens.
Appoint the public defender's office, waive presence.
What was the last name?
Lukens, Lukens.
Thank you.
All right, appoint the public defender's office, waive presence, bond is $2,500. All right, next, Daniel Val.
NBC.
We can waive his presence.
Appoint the public defender's office, waive presence. Here's probable, let me see. Defendant then shoved the defendant, but earlier he grabbed his arm, so there's probable cause for the charge. Bond is $5,000.
Judge, can we excuse the interpreters?
Is there somebody else there?
No, Your Honor.
There's not, who's the gentleman's
Oh,
name?
yes, there's a writing.
Add-on, Eric Williams.
I can excuse the interpreter, Ms. Coriel. Thank you so much. Please
Thank
come
you,
again.
Judge. Thank you. Have a good day. Bye.
Thank you. Who's this gentleman? A write-in?
This is Eric Williams.
Eric Williams on page, I don't know. These
What's
at
the case
end.
number?
Write-in, F25-21695. Sir, you were arrested for driving with a suspended license, third or subsequent conviction, resisting an officer without violence.
Oh, I think they said bond out yesterday. I don't have anything about his criminal history. Corrections, does he have any holds?
No.
Okay. Do you know what happened? He tried to bond out and then.
He needed to come to first appearance. He wasn't
Oh.
allowed to bond out.
2,500 count one, 500 count two. Let me see something. Yeah, there's 2,500 count one, 500 count two. It says revoke license. Yeah, that way you can bond out now, sir. Okay. Okay, the next are the refusals. A minute. Now we have,
All right, it'll pretty much be paperwork there now until lunchtime. Let's go back to Judge Stevens.
Yeah.
I see, Mr. Kimler was helping everybody. Was that a second job? He's still working?
He's good helper, Judge. He's gonna send the bill.
Okay. All right, 22-39416 is first call, the state of Texas versus Arthur Small Jr. That's you.
Yes, sir.
Present with your attorney, Ms. Peroso, and the state's attorney. Does the defendant waive a formal reading of this indictment and as well the second case we're going to be handling, 24 CR 702, a third-degree felony of assault public servant? Can we proceed in summary in both cases?
Yes, sir.
We will start with 39416 in summary, sir. This indictment alleges that on or about February 17th, 2022, in Jefferson County, Texas, you committed the first-degree felony of murder. You with the use of a deadly weapon, namely a firearm. Do you understand what you are charged with in this case?
Yes, sir.
An agreement has been reached in this case that you would be prosecuted for the lesser included offense of manslaughter.
Yes.
Stand by. That this is my
No.
what there is
No.
different. Which is a second-degree felony, which carries with it no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
Now. Manslaughter is found under section 19.04 of the Texas Penal Code, and this statute provides that a person commits the offense of manslaughter if he recklessly causes the death of an individual. An offense under this section is a felony of the second degree. You understand?
Yes, sir.
An agreement has further been reached by the parties that you would be pleading guilty, sentenced to 8 years in prison to run concurrently with this next third-degree felony of assault on a public servant case, and these cases would run concurrently. Is that your understanding of the agreements?
Yes, sir.
If I followed these agreements, sir, you have no right of appeal of your cases. Do you understand?
Yes, sir.
How do you plead to this lesser included manslaughter here under 22-39416? Guilty or not guilty? Are you pleading guilty voluntarily? That is on your own free will.
Yes, sir.
And because you are guilty.
Maybe essentially guilty.
So, you know, put on you.
There's a lot I gotta say. Okay, we're gonna hold that one in abeyance where we left off and go forward to 24 CR 702. And in this case, this indictment reads that on or about February 15th, 2024, it would have been like 2 days. No, these were on separate years.
Yes, sir.
Okay. In on or about February 15th, 2024 in Jefferson County, Texas, you committed the third-degree felony of assault on a public servant. Do you understand what you're charged with here?
Yes, sir.
Looks like somebody in Jefferson County Jail was assaulted. A guard or some member of the executive branch of government there. A third-degree felony carries with it no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand the punishment range for a third-degree felony of assault on a public servant?
Yes, sir.
An agreement's been reached in this case as well that you would be pleading guilty, sentenced to 8 years in prison to run concurrently with the preceding murder case. And is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Because I'm guilty.
show you what's marked as State's Exhibit 1 for each of these two cases you pleaded guilty to this morning. Did you sign those documents voluntarily? Understand them, discuss them with your attorney? Are the contents all true and correct? State's Exhibit 1 tendered into evidence
No
and
objection.
without objection admitted. Among other things, each of these cases, State's Exhibit 1 similarly state that you are mentally competent to enter your guilty pleas. They are freely and voluntarily made. You know what you've been charged with in each of these cases. You are guilty of these crimes and any lesser included offenses. You were giving up your rights to a jury trial in each case and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer, all true, so help you God. Correct?
You have to say.
State's Exhibit 1 in each case made a part of the record for all purposes. Pre-sentence report waived.
Yes, sir.
I'm going to follow these agreements if nothing further to add and find in each of these cases, sir, you are pleading guilty voluntarily. You are indeed mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 supporting your guilty plea in each case to find you guilty beyond a reasonable doubt in each of these cases. I now find you guilty beyond a reasonable doubt in each of these two cases. In 22-39416, the first degree murder, you are stand by. Since take forever. So in this first degree murder indictment, you are hereby found guilty beyond a reasonable doubt of the lesser included second degree felony of manslaughter as agreed by the parties. And I find you guilty beyond a reasonable doubt of that second degree felony. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 8 years in prison. And an affirmative finding shall be rendered on the judgment that a deadly weapon, namely firearm, was used in the commission of the offense. And in 24 CR 702, I hereby find you guilty beyond a reasonable doubt of the third degree felony of assault on a public servant. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 8 years on that third degree felony. These two sentences shall run concurrently, and you will be given credit for all time you have served in connection with these cases. Do you understand what's happened today, sir, in each case? Yes, sir. Anything else to add?
No.
That is all. Thank you.
Thank you,
Judge. Yes. Thanks.
Okie dokie, friends. Let's go back to Judge Boyd. She has another contestant.
5 jury panels. They deliberated Friday and all day Saturday, and then they declared mistrial.
See, and people were upset because in this court, we had a jury sequestered a while back. It was over the holiday.
It was a 3-day weekend, Judge.
It was a 3-day weekend. But it was great because I was living downtown.
Yeah, it's a difficult case. And that's the first 3 panels completely busted. Fourth and fifth were combined to get enough jurors. And then it was the week of testimony. And yeah.
Oh, wow. Well, we of course we're in trial every week, but we finished our trial, and then there was the sewage leak
That
on
was
the first floor, and I was just, people were asking me, "Is it the north end or the south end?" I'm like, I do left and right. I'm like, it's a way. Don't go out the way near the cathedral, and you'll be fine.
Yes. They had a lot of issues with inmates in the 226. Yeah.
Oh, we had to send, some didn't arrive, but at least we could do it by Zoom, so that was good. All right, the court is calling 2020 CR 2494B, State versus Willie Contreras. Can I have parties announced?
Jason Garahan for the state, Your Honor.
Jay Norton and Patrick Valentine for Mr. Contreras.
And are you Mr. Contreras?
Yes, ma'am.
All right, so we were actually here on September 25th. You entered a plea of true to violation of condition number 5. The state waived all other allegations without objection. Then we called it back for September 29th and counsel was in trial. So now we're here for today.
Yes.
State, what are you requesting? All right, and defense, what are you requesting?
Judge, our initial request would be just a huge change of circumstances. If the court would consider a revocation and then placing Mr. Contreras on 5 years probation, regular probation, understanding that he'll have the felony conviction, but circumstances are such now that he's clean, he's sober, his issues are behind him. He has a lot of family support here behind him. The court wants to hear from some of them. But basically, they will all, I've proffered that basically what everybody is going to say is he had his issues there. And quite honestly, he was going to test positive for drugs, and which is why he became a fugitive. It's been weighing on him. He hasn't committed any new offenses, but he's gotten close to in the church. He's now very set in his religious. He's a good family man now at this point. All of his family's here supporting him. Quite honestly, back in the day, they wouldn't necessarily be here, is what they say. But he has proven to them that he is a committed person to family, friends. He's in a long-term relationship. I think it's an unusual set of circumstances. I understand revocation or termination, but Mr. Contreras is asking if the court would allow him an opportunity to be placed on probation. He'd start over 5 years instead of 2 years, and he will be successful, Your Honor.
But has he done anything on probation?
He was not a good candidate for probation back then. I mean, short answer is no. He didn't do what he did not meet his obligations on probation.
I mean, did he ever report?
He did. No.
Okay. All right. And state?
Yeah, right. Obviously, I did not deal with this case previously, but Melissa always had, I believe, recommended 1 year, or that's what we requested state judge.
Okay. And probation, you recommending revocation?
They are, Your
Summary judge. Revocation.
All right, so this is what I want to tell you. I appreciate the fact that you've changed your life.
Yes.
But you haven't done anything. So.
Just one thing to add, Judge, I forgot. He's current on all of his fines, and he took a UA, and he is also clean as he stands.
So I'm going to give you a choice today. These are your only choices, right? I am going to grant the motion, revoke. So the state is asking for 1 year state jail. You can either take the 1 year at the state jail facility, and the only reason why I'm giving you this choice is because it appears that you've changed your life, right?
Yes, ma'am.
And sometimes when we change our lives, and then we forget, we want everybody to forget about everything else, and that can't be done, right?
Yes, ma'am.
So you can either do a year at the state jail facility, or you can do a year at the Bexar County Jail. If there are no objections, I'll do a 1244.
Bexar County Jail.
Is there any objection from the state to the court? All right. And all right, this is what the court is going to do. As previously stated, the court found violation of condition number 5 true. The court is going to grant the motion, find you guilty, revoke. The court will sentence you to 365 days at the Bexar County Jail. Give you credit for any time served. Let me see. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review the document with your attorney? Did you understand it and sign it?
Yes.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. At the Bexar County Jail, I'm not in charge of you receiving a credit of 2 days for every day you spend in jail or 3 days for every day. That's completely up to the sheriff's office. You understand?
Yes.
Now, I could send a message to the sheriff and say, I want you to serve 365 days flat.
Yes, ma'am.
I normally don't do that. I have yet to do that. Now, maybe there may be somebody that should be done for, but I'm not going to do it for you. So that's completely up to them. So please do not call the court or have people call the court and say, I'm not receiving 2 for 1 or 3 for 1, because I'm not in charge of that and I have no control over that.
Yes.
You understand?
Yes, ma'am.
All right. All right, good luck to you.
May we have a moment just to explain what?
Sure, just speak with the deputy.
All right, let's continue hopping around back and forth in Texas. We'll go back to Judge Stevens.
Thank you for that pregnant pause. That we were all excited there for that. In summary, paragraph 1 alleges that on or about November 24th, 2023 in Jefferson County, Texas, you committed the offense of theft. Paragraph 2 goes on to allege, though, that you have 2 or more theft convictions. And actually, I'm reading 3. 1 in 2005 from County Court of Law 12 of Bexar County, Texas. Another in 2011 from Dallas County, Texas. And in 2011, the County Court of Law out of Bexar County again. So 2 or more. Each time you steal a pack of gum, it's a felony from here on. All right. So a state jail felony means if convicted, you face no less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand the punishment range you are facing on this case and any other theft that you might, which is a good deterrent, I would think, to making sure that you live honestly here on. An agreement's been reached between the parties, so you would be pleading guilty and sentenced to 7 months in the state jail. And then this other case, 24 CR 597, that looks like fraudulent use or possession of identifying information. That case is to be dismissed. Is that your understanding?
Yes, sir.
If I follow these agreements in each case, you have no right of appeal of your cases. Do you understand? How do you plead to this 596 theft case, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
I show you what's marked as State's Exhibit 1 here. Did you sign that document voluntarily, understand it, discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. And the state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses, and you're giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God. State's Exhibit 1 made a part of the record. For all purposes here. Pre-sentence report is waived.
Please, John, yes.
I will follow this agreement and find you are indeed mentally competent to enter your guilty plea. It is indeed freely and voluntarily made. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted here to support your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of paragraphs 1 and 2 of this indictment. Paragraph 2 alleging those prior convictions of thefts in these other counties, and those are true and correct as they are alleged, and you are pleading true and correct to that voluntarily. Is that true?
Yes, sir.
I find this state jail felony supported by the plea and the paperwork, the records filed in this case. I now find you guilty beyond a reasonable doubt of paragraphs 1 and 2, the state jail felony of theft. And following this agreement, you are hereby sentenced to confinement in the state jail for 7 months. And will be given credit for all time served in connection with this case. And let me get to the other thing. 24 CR 597. By agreement. Then I don't know. I don't know if this came out right, but the machine's back to playing again. That case is dismissed.
Thank you.
All right. Anything else?
The only other thing is I'm not sure if she has to go into custody or not. She has over 7 months credit already. If she does have to go into custody, can she do it on Friday? She has a job and is working. I
think you have to do that. You have to go in, and then it's up to the officials to calculate, but there's no objection to that.
No objection from the state.
And it's not an aggravated offense, so I'm going to order you to report into the Jefferson County Jail on or before 6:00 p.m. Friday. If you fail to do that, then you've got another new charge that would be added, which you don't want. You got to fix all of this and move on with your life.
If she wants to have a seat in the jury box, we can call the jail to see if she has to.
Or we can do that too.
I mean, just in the case that she does, she could go on Friday.
Yeah, but I don't know of anybody who enjoys going into the jail.
Right. If she doesn't have to,
Except
she doesn't worry about it. So just give us some time. Let us call the jail and see what they need from us.
Okay, finally, let me I've got Daryl Johnson's case here. Kenneth Jackson and Howard Price, all part of the trial docket, and we have included all of that.
Sorry. All right.
Here is, I don't know that anymore.
You want half the staff?
Yeah.
There's. I'm running, see if we can make that phone call real quick.
Thanks.
I got busy playing with Ellie and didn't realize that that hearing had ended. Let's go back to Judge Boyd.
And the Lincoln lawyer. Have you at least read the books? Oh my gosh. Well, there's a scene in it where, the defense attorney is asking for a continuance because they have a missing witness. And the missing witness is Mr. Green. So now you know what I mean, right?
I got it. Every time I hear Mr. and then color, I think of Reservoir Dogs.
Oh, yeah. Oh, yes. All right. Are you all still having your contested?
No, Your Honor, we've reached an agreement, I believe.
All right. The court is calling 2020-23 CR 10024. State versus Reginald Tyrone Green. Can I have parties announced?
Those for the state.
Andres Camping for Mr. Green.
And are you Reginald Tyrone Green?
Yes.
Did you review the documents entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Reginald Tyrone Green who was placed on deferred adjudication in 2023 CR 10024 for the offense of unauthorized use of a vehicle on April 16, 2025 for a period of 2 years? Is that you?
Yes, sure.
All right, state.
Violated condition number 1, on or about the 21st day of May, 2025 in Bexar County, Texas, the defendant Reginald Tyrone Green committed the offense of theft in violation of condition number 1.
How do you plead to that? True or not true?
True.
State will waive all others.
Any objection?
No objections, Your Honor.
All right, did you understand by pleading true to violation of condition number one, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number one? Court will find violation of condition number one true. Is there a proposed agreement?
Yes, Your Honor, the proposed agreement is to grant state's motion to revoke sentence to 180 days in the state jail facility and take into consideration clause number 2025 CC 007955.
All right, and that cause number, what is that cause number?
That is the theft degree pleasure too.
All right, and then as a part of your previous plea bargain agreement, the court was asked to take in consideration county court cause number 70, if everybody could write this down, 709056 and 709057. And what were those cause numbers? The offenses.
Probably close to the one that we're
Yeah.
taking in 007955 and then 707056.
All right, I'll see if I can look it up.
Well, she looks that up. Barbara, thank you on behalf of Ellie for the $5. Very much appreciate that. We'll make sure she gets a nice treato for that. Thank you so much.
Yes.
So cause number 709056 is a criminal trespass, and the other is a resisting arrest.
All right. So what has he done on probation other than pick up another theft case? Has he completed anything?
Your Honor, I don't believe he has been out on bond long enough to complete anything. It's my understanding that Mr. Green has been struggling with some mental health issues and is ready to accept any and all help that the state will offer. The underlying offense, I believe, is a unauthorized use of a motor vehicle that stems from a confusion with his parents. His father is here, present, and is standing behind and supporting Mr. Green. I do not believe that Mr. Green has successfully completed any of the other conditions of his supervision, but the desire is to pay his debt to society and then to relocate up to Texarkana with his family. And then be with his support network up there so they can help assist him in getting on track with everything.
All right, what I can tell you both is I don't think 180 days is appropriate. He was on probation for unauthorized use of a vehicle.
Yes, sir.
Which is sort of close to being a theft. Sometimes the state will file it as a theft of a vehicle. Sometimes they will file it as just unauthorized use. And then while he's on probation, he's released and he immediately picks up with another theft case. That's in May.
Yes, Your Honor. The theft cases, I believe, are shoplifting, not a forceful dispossession. And from what I understand, there may have been some other factors at work, but from our perspective, the decision to request that the state offer Mr. Green the ability to serve some time on their revocation was something that was agreed upon by all parties to help facilitate Mr. Green's getting past all of these incidents. I do believe he has a number of days in custody as credit that we would ask the court to attribute to him.
But he has an unauthorized use that he's on probation for April 16, 2025. He doesn't do anything on probation. The only thing he does is pick up another theft case on May 21st, 2025. I'm assuming he gets arrested at some point in time for that, gets released, and then in June, he's alleged to have committed another theft of 2025. I just don't think 180 days is appropriate for him because he hasn't done anything on probation other than pick up new offenses. Y'all are dimming the lights. All right, so this is what the court is going to do. The court is finding you guilty, finding, as previously stated, found violation of condition number 1 true. The court is revoking. The court is taking in consideration 2025 CC 007955. The court will sentence you to 14 months in the state jail facility, give you credit for any time served, and the court will request the therapeutic community.
Your Honor, if the court would entertain a little bit of testimony as to the underlying, if that might
sure
have the court can reconsider in its assessment. We would like to call Reginald Green, Senior, to testify.
While the witness comes up, Barbara, thank you for $5 for the bunnies. Very much appreciated. So we have this 15-year-old that we know who is an entrepreneur. She runs a rabbit treat business, and they're really good. So we'll use that $5 with the next order that we place with her and support a young entrepreneur. So thank you so much.
Who are you in relation to Reginald Tyrone Green?
That's my son.
Okay. And are you familiar with the underlying charges of the unauthorized use of a motor vehicle?
Yes, that was our vehicle that we gave to him. He was going through a breakdown at the time. He brought the car to get the what's called miles to get some work done on it. It came up to be $1,000-something. With his breakdown, he just figured he could go get the car, take the car. The people saw his state. They didn't press charges. We paid the $1,000, but my wife decided to take the car back because of his mental state.
Okay, so let me stop you right there. So here's the thing. Once somebody has been placed on probation, they're placed on probation. It would probably be best for you if you are now saying that he is innocent of these charges, didn't commit these charges. That's something for the public integrity unit of the district attorney's office. But I cannot legally go back and undo the fact that he's on probation.
He mentioned it.
Yeah.
I understood.
So here's my thing. Why, if you know, why is your son, he's on probation for a theft case, and he, the unauthorized use, and he continues to pick up more theft cases?
Because he was going through a mental situation. We committed him into the hospital because.
And when was he committed into the hospital?
I can't recall right now, but it is record that he was there. But the thing is with Reginald is with his kids. His kids are more important to him. His wife used his kids to keep him from seeing it. Because he's not stable, he gets upset. So that's why she puts him on where he can't come. Then, so he don't know how to handle that. So he do things like he really don't have a place to live. So when he was stealing, he was just trying to get it wrong. I've been trying to get it to Texas County because I know I can help him. But leave his kids. No one wants to see them. If you knew Reginald, you would know. He's a person that gives assurance. He's a hard worker. It's a long story. He don't just get here. This was a long process. That trying to do the right thing instead of hitting the wall. He got arrested this time. He was on his feet. By him being on his feet and get arrested, he loses his job. So now he starts over. Now he has no, because the main thing is for him, his paying his child support. His father was taking his majority of his whole check because he had 3 children. He loved his children. He had a problem with that. But when he lost his job, he had nowhere to live. So again, he refereed whatever hustle he could get to get a room, just a roof over his head. And that's what he was supposed to.
All right.
And so, Your Honor, I offer this testimony.
Well, just one second.
My apologies.
Do you have any questions? All right. Thank you so much for letting me know about your son.
Your Honor, I offer this testimony so that the court could maybe reconsider its decision in its sentencing, knowing that Mr. Green is going to be getting the help that his family wants to offer, and that they would love to have him come up there to Texarkana, but they do understand that he needs to be admonished and punished and has to take some responsibility. And they're not trying to obfuscate that, and they're not asking the court to ignore that. They're just asking that if the court would to follow the plea agreement, that they believe that they would be able to be in a position to help Mr. Green once he is done with his sentence and can be back with his family in Texarkana, hopefully to get him back on his feet and assist him in any other way possible, as not just being his family in present, but also being someone that he can rely on and not have to.
Do you have proof of his mental health issues?
I do not on me at this time.
All right, so this is what the court is going to do. The court sentence will remain to guilty, revoked, taking consideration 2025 CC 007955, 14 months in the state jail facility, give you credit for any time served in the therapeutic community. If your counsel brings proof to the court of mental health issues, proof to the court from your family of some sort of plan, then the court will reconsider if the state has no objections. And I say if the state has no objections because there truly is no legal motion that's a motion to reconsider. Once the court enters a legal sentence, that legal sentence stands. So the state would have to agree to allow the court to reconsider. Do you understand?
Yes, please.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are in deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over that, you'll need to speak to an attorney. Do you understand?
Yes.
All right, thank you. And when do you anticipate having that information?
I will get it to the state if I can before the end of the week.
All right, then you need to speak with Ms. Ferguson about putting it on the docket for a motion to reconsider.
Yes, Your Honor. Thank you
Thank
very
you.
much.
Lindsay, thank you for $5 to support the Rabbit Treat Fund. So I dropped a link for that young lady's store in the chat. Feel free to check that out. She does rabbit treats, but Beth reminded me she also does dog treats and cat and dog toys as well. Everything is like homemade by her, so very cool stuff. Be sure to check that out and support her. We've been kind of shepherding her along for a couple of years now.
She does custom orders too, so if you message her and you want something specific that you don't see, she'll try to find a way to do it.
Yeah, Beth just said she does customs as well. Barbara says, wouldn't it be better to use your donation link? So Barbara, I meet people where they are. If you want to donate to the channel through Super Chats, that's always appreciated. If you want to use the link on the website, that's appreciated as well. Yes, technically I do keep more because that website is our property, whereas YouTube takes a cut for anything that happens on YouTube. But YouTube also hosts all of our videos and gives us a platform. So, you know, you have to look at it that way as well. Let's go to Judge Stevens, I guess. We'll just keep hopping back and forth here in Texas. Whoop, let's not. All right. His feed just reset, but let's go back to Judge Boyd.
All right. right, what is happening with this case?
Judge, we have a plea agreement worked out with the state. However, I need to obtain some additional information from my client. She does have it in her cell at the jail, some timesheets and some judgments. So I intend to go there within today or tomorrow.
So if you have an agreement worked out, why can't you do the agreement?
We just need to get those timesheets to present to the court, Judge,
Timesheets for?
for time that she has spent in custody, Your Honor.
Oh, they'll be able to look that up.
I don't believe that they saw the reflection when I was speaking to the staff.
Well, I can tell you, if you enter a plea bargain agreement, the court is going to grant you legally, I must grant you any time that you served in custody. And if there is something that you feel as though you're not being given credit for, they do a nut pro tunc to make sure you get your appropriate credit. All right?
Okay.
So if y'all will complete the agreement, please.
All right, Judge.
Thank you.
So the court wants to go forward without having
Yes.
the proof today? Okay.
Anyone else ready?
Please come.
All right, thank you. Anthony Jacob Herrera, I think that's been done.
So she's advertised.
All right, let's go. We'll stay in Texas, but Judge West.
Murder and Mr. Galmore. Mr. Nichols, what's the announcement?
Judge, I don't think we're ready to set this for trial yet. I know it seems like every hearing I tell you there's stuff we need to investigate and find out, and there is still in this case. There's a potential witness who has given unsworn statements that is basically blown off appointments to give a sworn statement, and we need to run her down.
That's what we were gonna do last time.
And they made appointments and she didn't show up.
Well, if we're talking about that one witness, she did meet with the investigators between.
Okay.
But there's also a new witness,
Oh, another, okay.
And possibly some video footage that was deleted that I believe that Port Arthur Police Department is trying to get their hands on.
I need to check the status of the subpoena for that video. We need a little more time to it.
Okay, all right, we'll just do a normal reset. Y'all can work on that. We'll see where we are at the next court date. Mr. Freelo, make sure you stay in touch with, did you have something
Yeah, I
else?
could, yes, Judge. I don't have a motion necessarily on file, but Mr. Freelo currently is on house arrest with a GPS device. His wife is recently been unable to return to work to the federal prison, so their income is limited. He's trying to find a job. It's been difficult, obviously, with the thing hanging off of your ankle and whatnot. So we were asking the court if the court would consider removing him from house arrest and GPS requirement.
No to both of those things, but potentially to, the GPS is gonna remain on. I would consider, Mr. Nichols, what's your position with regard to him looking for work and getting a job?
I'm in favor of that, Judge, but I agree with the court. I think the monitoring needs to stay in
For
place.
now, at least, you know.
Monitor moving from house arrest?
Mhm.
Okay.
Yeah. Wear long pants and cover it up, you know, I mean, whatever you need to do. But at this point, I'm not willing to do that based on obviously the nature of the offense. And so if you do this, Mr. Galmore, if you'll just send maybe a memo over and copy Mr. Nichols on it so that I have a paper trail to say that you asked me and that I granted that part of it, and I'll just sign off on a memo. It doesn't need to be a motion.
We'll do
But
that.
that'll just remind me to get it in the file so that it's clear. Also, we can send that to whoever has his GPS monitoring device so they know it's just for work related purposes. You can go find a job, go to work, things like that, but it's not just a full on go do whatever you want kind of
Well, Judge,
release.
actually, that's currently the status. He is allowed to leave only for work purposes currently.
Okay.
But because his wife is unable to work, her medical conditions made it much more difficult for them. So if the court would still consider just removing him from house arrest and keep the GPS, that would probably help a lot with other life's necessities.
Okay. I know you've asked for him to drive her to this, there's been
Yeah, he had to take
doctors.
her to the airport the other day. But I mean, obviously in life, a lot of things like that pop up regularly, and if he's gonna wear a GPS device, you know, the court will always know where he's at if that's important. But removing him from house arrest would be probably a big help.
Mr. Nichols?
Hard for me to really argue with that reasoning, Your Honor.
Okay, so I am going to require for you to remain in Jefferson County without permission. So if something happens, like the other day with the trip to airport or whatever, get with Mr. Galmore, he'll send me something, I'll approve or not approve. In Jefferson County, do what you need to live your life. I don't want, I mean, that doesn't include going to bars or going out at night
Maybe a
or,
curfew is appropriate, Your Honor, unless,
yeah, that would be,
I mean, if he ends up with a night job, obviously, that's different, but.
so let's do this for now. Let's make a, I'll release the house arrest, remain in Jefferson County with the curfew 8 p.m. to 6 a.m. If you get a job that interferes with, just get with Mr. Galmore and get those hours, whatever the job is, and we'll work around that. But primarily, I want you doing necessities away from your home, and that's it at this point, okay? All right,
Judge.
thank you.
Thank you, Your Honor.
One more. Brandon
Yes,
Broussard.
Brandon Broussard. Yes, ma'am. Okay. Good morning, sir. You're Brandon Broussard. And this is 24 DCCR 1150. Mr. Broussard's charged with aggravated assault causing serious bodily injury. Mr. Galmore, what is the announcement?
Judge, we're asking for another announcement day just to continue go over any of the evidence and getting with the state, see if we can resolve this without putting on trial docket.
All right, looks like you've been on since June. I'll do one more. Mr. Broussard, you need to make sure, stay in touch with Mr. Galmore. Y'all go over everything. Because at that next court date, we need to get an announcement whether or not this is going to be a trial or if it's going to get worked out, okay? All right, we'll see you at the next court date.
Thank you, Judge. That's all I have.
Thank you. This is Mr. Frazier.
All right, friends, only a minute or two left, so this is a logical place to leave it for today. I hope everybody had fun today. I know I did. We got to see a new judge. I got to work frantically behind the scenes because a bunch of things were busted, but we got it all working again, and we made the best out of a Monday. So appreciate all of you. Thanks to everybody for your super chats, and Barbara for the gifted membership as well. And thank you to Lindsay, who is already looking to show support to Thumper's Crafts. That is a 15-year-old young girl that we've been shepherding along for a couple of years, and she just does wonderful work, so appreciate that. We'll be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, 45 minutes early for channel members. Somehow we still managed to be a minute or two late for the live show, even adding 15 minutes to the pre-show. But we'll keep working on that. And, yeah, go have yourselves a good Monday. Look forward to seeing you all tomorrow. Take care. God bless.